This is a mining matter in relation to the state of Karnataka, in which a 3-judge bench has to be constituted. My previous mentionings were allowed by this Honorable Court. I'm really grateful for that. However, the matter has still not been listed.
Hello, this is the... This is that Samaj Parivartana.
Samaj Parivartana matter.
There's some...
Most probably in February and or March probably at least.
There you go. There's some urgency, my lords, because the mines are not being operationalized for over 3 years due to CEC observations.
We are already in February. Maybe we are trying because we have to manage certain matters that...
Most grateful. Most grateful.
Milord, I want to just clarify. I have given the IA numbers that has to be withdrawn. All the petitioners have withdrawn the case.
So all the petition mean then your SLP...
SLP is withdrawn. Deeply obliged. Deeply obliged, Your Lordship.
So hope now this order is the final order.
Yes, Your Lord.
All right.
One, my lord, I have done 3 things. I have filed, my lord, an affidavit in reply and 2 status reports, one for CBI, another for ED. And as per, my lord, my reply, the approximate siphoning of the funds we are looking at right now is about 40,000 crores. And the investigation is ongoing. This is, of course, my lord, bank's public money.
40,000 crore. But
40.
There are 2-3 disturbing things. One is that are you presenting CBI also?
Yes, yes, my lord. CBI, ED both.
Now, CBI says that on the basis of the complaint received from one bank, FIR is registered, matter is being investigated. Meanwhile, from other financial institutions also, complaints have been received. Now they say we want to register separate FIR.
We do. No, my lord, what we have done is I have taken specific instructions on that. The first FIR came from the State Bank of India. Thereafter, my lord, other banks also intimated us about their, my lord, alleged siphoning, etc. That is also now included, and it's a part of, my lord, the investigation. Because we cannot have separate FIR.
These complaints, are these not, will these not amount to constituting a separate independent offence? Nature of the offence may be same.
Yes, my lord.
Nature of the offence may be same. But in terms
the
of
transaction as, my lord, used
the
in the judgment
complainant is different. The time of transaction might be different. The manner of transaction also might be different. Ultimately, so therefore that will constitute an independent offence. Why are they not registering those?
Lord, that can be done. We will examine. Possibly, my lord, there was a consortium lending. If that is so, then perhaps, my lord,
if in the case of consortium and the lead bank has made a complaint, understandable. That will, provided that the lead bank says it is for and on behalf of all the banks.
No, my lord, the lead bank says only for it. That's correct. No, we will examine that, and we are not averse to registering separate offences if these are separate severable transactions. There is no difficulty.
Actually, my lord, in this case, this FIR has been registered in 2025. The Bank of Baroda's audit report came in 2020, in which they had detailed the manner in which the funds have been siphoned out, etc. So the bank, unfortunately, did not, for 5 years, did not lodge this complaint with the CBI. Only in 2025, they seem to have lodged that complaint. And till today, my lord, only after your lordship issued notice, they have effected the first arrest in the matter day before yesterday. Till today, my lord, in a bank fraud of this kind, this is the largest corporate fraud in this country.
Now that it has been brought to our notice,
yes,
and we will continue to monitor it.
Yes.
And we will ask them to file status report.
Yes. That's what
that will have to be done.
That's what we want.
My lord, may I make a submission? My lord, I appear for R5. There are, my lord, 5 FIRs by CBI representing, my lord, a large number of banks. There are 3 ED, my lord, ECIRs based on that. There is 12,000 crores worth of attachments, my lord. There are, my lord, more than 100 summons issued to various people, my lord. They are cooperating. It's not nobody is running away, etc. So, my lord, whether we have an SIT or whether They are going on. In the affidavit filed by ED, they have set out, my lord, all this what I am saying, that this is what they are doing. And they say that, my lord, they are doing it with great speed, my lord, etc., etc. That's for them. Now, as far as, my lord, I am concerned, I had a proposal to make. I am not, my lord, averse to an SIT or whatever, my lord, I am not opposing. I have a proposal, my lord, in the sense, my lord, since the government is here, it's a matter, my lord, of money. They say it is siphoning, I say it's not siphoning. But whatever it is, there could be business losses, etc., etc. I have not run away, I am very much here. My lord, if through the good offices of the court and the government, if they can form a committee, my lord, of finance people like SBI, RBI, etc. And my lord, let's have a look at it as to what is the amount due. And if this gentleman or his companies can pay in some staggered form, it can be, my lord, that is one way to look at it rather than going only for prosecutions. That's, my lord, my instructions, and I'm stating so on instructions.
My lord, I have something to say on
I have
that.
a comment.
Only a
have
minute,
taken-
only a
Said
minute.
to my lord, the Chief Justice, my lord, taking a call
Loan.
on the
My
government.
lord, only a minute, my lord. We, the banks, my lord, conducted a forensic audit by an outside forensic auditor, my lord. And the forensic auditor has said that there is siphoning and other things, my lord. My lord, we may perhaps not be able to, my lord, compound these offences, my lord, even if there is a readiness to pay.
Mr. Solicitor, in spite of what you are submitting, see paragraph 27 of the CBI report. You are dwelling on 17 capital A again. If the forensic auditor says that there was a breach not of loan terms but of collusion, then what is the question of stopping the registration of RCs in view of taking sanction? These are
Well, I-
clear
at this point-
operations. Please
that is-
examine.
I will answer my lord's question. I have put it to the government, my lord, to the CBI.
23 may
That was, in fact, my next.
Yes, your lordship's question is very pertinent. My lord, the public officials are also under the investigation. They are also under investigation. Number two, the respondent number 5 and his possibly respondent number 5, the individual, filed suits in Bombay High Court, and there is, my lord, an injunction granted not to act upon the forensic audit report, my lord, on the ground that the person who signed the forensic audit report is not a member of the Institute of Chartered Accountants. I am not going into it. Banks have filed an appeal. Appeal is heard and the judgment is reserved. My lord, I appeared for the bank as well. My
I appeared on, that's a completely different issue.
different thing, my lord.
We are
But-
entitled to say a report is good or bad.
No,
That's a
I'm not on the merits.
That matter has been argued, so we'll wait for the.
Yes.
Your judgment will come soon in a week or 10
Even an
days.
injunction has to be subject to 41 of the Specific Relief Act. You can't get an injunction on
Lord,
registration of an
injunction
FIR.
perhaps may not apply even
Absolutely
to
not.
an independent
But we are not
investigation.
arguing that case here, my lord. Question is, there is a report which, my lord, declares me as a fraud. Report is issued by a person who is incompetent to do so. So I am questioning that, that's
Mr.
all.
Rodriguez, there are two things.
Yes,
If there is an intention to
Yes.
siphon the public funds
yes,
from X to Y, Y to Z,
yes,
from the very beginning, and if that has actually happened, then probably the solicitor is right in
Yes.
saying that this kind of offense can't be merely because you are willing to pay.
agreed, my
you
lord,
pay.
agreed.
That
Agreed.
cannot amount to condoning.
Absolutely right. But, my lord, it is my case. There was never an intention. We have done business, my lord, for
That is
40
what-
years.
That is what precisely
Yeah,
has to be seen on the basis of the investigation.
no problem.
Now,
Investigation,
as my brother has pointed out,
No problem.
we will not allow this kind of impediment that 17A sanction. If the bank officers or some officers.
They are
found
also
to be-
under investigation. I am instructed.
If they are not involved, it's fine. But if they are involved, then they must
If
also.
they are
face
in
the burden.
collusion or in any way accomplice, then they are also under the investigation.
That's okay.
I am
I am
authorized-
not opposing, I am not opposing anything. I have come, my lord, with a proactive stance. I have cooperated. I will cooperate. Whatever else your lordship will direct, we have.
What you are suggesting, Mr. Roki,
Right.
that can be, that can only be probably from your side. It
Yes.
has come. Provided that after thorough investigation, someone says that it was a case where the default took place for the reasons beyond your control.
That's right.
Out of the alleged.
No problem.
It was not misappropriation, misapplication or something. But
That's
if
right.
it's a deliberate siphoning of,
But it can
it's a
happen.
criminal offence.
It can happen, my lord. People
Even-
do go bankrupt.
even
It's
if
not
we
that every
ignore-
man, my lord, has taken money and run away.
Manoj, I just want to
Even
comment
if
here,
we
because
ignore
if your lordships will just permit.
the audit report of the bank, the ED in their counter affidavit is saying that they have found evidence of forged bank guarantees being given by them. They have
Then itself is a
It's a
independent
criminal offense.
offense.
Therefore, I said it may not be possible to
forged bank
compound that
guarantees,
offense, my lord, merely
siphoning
because
out
somebody.
to all these tax havens. At least 26,000 crores has been siphoned out to these tax havens like Mauritius, etc. Not a single penny has been coughed up. They have declared bankruptcy in all their companies. 1,78,000 crores of outstanding dues in these companies. 1,78,000. The only amount recovered in bankruptcy proceedings is 15,000 out of 1,78,000. Most of the money has been siphoned out. That gentleman, my lord, who owns all these companies, he has not been arrested till date. Till date, my lord, the main person, the kingpin of this whole scam has not been arrested. Only they arrested one officer of this company 2 days ago, day before yesterday, only because of this matter coming up.
No, not because of that.
We will not comment, Mr. Solicitor, but then it's a very serious.
Lord, we are before your lordships and we will have to ensure that your lordships' conscience is satisfied that the investigation is impartial and going in a right direction.
Today we are not passing any harsh order because someone may not take it that our order has caused prejudice. But we expect that your agencies must act fairly, independently, and very swiftly. We would like to have status report every month. In 4 weeks, they must submit the report, and let us see how you take the investigation to what logical conclusion.
Please.
If so much, such a huge amount has been siphoned.
It is.
Then we are.
Lord, this is not correct. This is absolutely not correct. Just banding figures like this.
Just 2 points.
It's absolutely
I
incorrect.
just want to clear the impression.
One you are presenting.
I'm appearing for respondent number 4, which is the group of companies.
The companies.
Here, Manoj, I might just mention that the service, because the impression carried, I think last time when your lordship passed the order, was that service was effected and we were not appearing. In fact, we have received the papers only after the 31st of January, because I don't know which address they went to etc.
Anyway.
But anyway, now we are on record. We've placed our thing. We'll take some time to put in our response.
That's it. Okay.
I'd be grateful for that. The second point which I want to mention, because a large number of figures have been bandied about, that in the last 5 years, 2 of the companies, Reliance Infrastructure and Reliance Power, have paid back a total of 20,000 crores of rupees. 20,000 crores of rupees. Now, this is a very, very important
The
element.
amount is 1,78,000.
Lord, this
What I'm trying to get,
This
what
is not
that
correct.
people see, Milord, that those
This
figures
is not
are being
correct.
bandied. What we are trying
Absolutely
to
banned.
project over here is that when a party has repaid 20,000, and these 2 companies are now virtually debt free. I mean, there will be obviously some requirement for working capital,
thousands of
etc.
shareholders.
But it's over, Milord, something like 50 lakh shareholders, small investors are there as far as these 2 companies are concerned on the aggregate. So this is, Milords, obviously a group which repays the amount. Now we will, there, as your lordships may have seen from we don't have the advantage of the report, but we do have the Enforcement Directorate affidavit which has been
Yes,
filed.
we have.
Where there's a series, the affidavit says that there's a series of steps and measures which have been taken in the last 6 months. So there's a relentless, Milords, effort. We are trying to ensure that the payments are made, and there is no question, Milords, as far as this suggestion of siphoning, etc.
Just one company.
Anyway,
Not
we
only
will
one
bring-
aspect.
And therefore, my lords, I think the suggestion which was made by Mr. Rothi is a valuable one. Most of you see the Enforcement Directorate affidavit also. That's all that we have. They have talked about public funds, etc., being siphoned away or being removed. Now that doesn't seem to be the correct impression, which the Enforcement Directorate, but they are entitled to their view. So therefore, if there is some solution which can be found to bring this out, at least it reduces the issue, because that's the primary
There are
purpose.
two
of
So let us see that.
Let me respond, my lord, on 2 aspects, my lord. Number 1, Lord, in the forensic audit report, Lord, it has come out that in some cases the money is taken as a loan from one bank to repay the another bank. That may be, my lord, I'll have to check up, my lord. That may be the way in which, my lord, this is repaid. Second, my lord, this suggestion placed before your lordships may not be utilized in other forums that now Supreme Court is considering constituting a committee which will go into what is payable and how to pay it.
No.
Because there are suits and petitions pending.
Mr. Sheffield, we are not constituting any committee today.
Yes, my lord. Right.
We are still expecting and we are hopeful that CBI and ED will do their job. They know how to do it. We are expecting them to perform it. If at all we find that yes, there is some kind of delay on their part, or if they are evading anything, then we might require to,
No, certainly, we are before your lordships, my lord, and
Lordship may see that, and then take a call. We have no difficulty. We are not.
Just two companies of theirs have outstanding, the Reliance Communication Infra had 47,000 crores of outstanding dues. In bankruptcy, it was sold off for 455 crores, 1% of the total outstanding amount, and sold off to whom? To the brother's company. And the other one, my lord, Reliance Communication had 47,000 crores of outstanding dues. Just two companies have 95,000 crores of outstanding.
Lord, resolution is pending.
Sold off.
It's a public process. It's a public process. It's not that I am buying or brother is buying. Anybody can come forward and buy or not buy.
it's not
The
buying also, it's a resolution plan being.
unfortunately, IBC platform is nowadays is being misused like anything.
That's,
You get the company, all the assets undervalued, then you indulge in a kind of an auction, which is also a completely a pre-planned game.
these kind
Lord,
of.
only one thing.
Somebody from the family or close friends or someone comes and buy it.
Lord,
If the brother has done it, the value assessed is something different.
I don't know about blood. I'm not aware.
Apropos what has fallen from my lord the Chief Justice, the government of India is also seriously considering this issue, my lord, in IBC. And I cannot, my lord, say much. I'm a part of the discussion, but it is under a very serious consideration.
Because every day the matters are coming, and this is one of the issues that every day we are facing.
My lord, the haircut is phenomenal, sir.
And the bankruptcy is declared by the very company which is facing bankruptcy. They ask one of
Voluntary declaration, then your own people evaluate you. That evaluation is not even 1%, 10% of the actual market value, and then eventually you find out this. Unfortunately, this resolution professional or whatever designation is given, every day I keep on observing. Their conduct is also not above board. So let us see that after 4 weeks that
We
how
will
it
see that.
come out.
No difficulty.
Please, sir.
Mr. Bhushan, all these facts are there on record now.
Everything is on record. Everything is on record.
Lord, we
Yes, my
will
lord.
also respond, my lord, to these figures. They are not correct. We will respond.
Say in reference to the order dated. January 2026. Respondent 4 and 5 have entered appearance. Their learned senior counsel seek and are granted 4 weeks time to file the counter affidavits. Then say Mr. Solicitor of India, Mr. Tushar Mehta and Solicitor of India, you are representing both ED and CBI.
Both, yes.
Representing the Enforcement Directorate and Central Bureau of Investigation state that like this, the Enforcement Directorate and CBI have also entered appearance through the Solicitor of India. The Enforcement Director has also filed an affidavit. In some and substance suggesting that the investigations for the purpose of detecting the offences under PMLA as well as into the affairs of the group companies are going on. It is pointed out that ECIR STF 17/2025 has been registered in relation to the Reliance Commercial Finance Limited and Reliance Home Finance Limited. The investments made by Yes Bank between 2017 to 2019 in non-convertible debentures and commercial papers of both RCFL and RHFL are being examined. According to ED, it has been found that RHFL borrowed public funds from 33 banks, stock financial institutions, and committed a default of rupees 7,523.46 crores. It is further claimed that 33 lenders have been able to recover only rupees 2,1106.28 crores, with a net default of 5,407.18 crores, which constitutes the proceeds of crime. As regard to the default committed by RCFL, it is pointed out that 21 banks, stock financial institutions have been defrauded to the tune of 6,280.57 crores, as out of 8,226.05 crores, only a sum of which 1,945.448 crores has been paid. Another ECIR stroke STF stroke 26 stroke 25 has been registered in relation to Reliance Communication Limited, inter alia pointing out that the total outstanding amount is 40,185.55 crores, which constitutes the proceeds of crime. It seems that one ex-director of the company has been arrested recently and is in custody till 7th February 2026. Next paragraph. The third ECIR stroke STF stroke 14 stroke 25 2025 pertains to Reliance Power Limited. It detailed the factual details of the RPO WER courtroom, entering into a power project agreement wherein forced bank guarantees are alleged to have been submitted. Defects were submitted. The total loss said to have been caused to the public money is 105.98 crores. 3 individuals who have been associated with the aforesaid company have been arrested. Next paragraph. The Enforcement Directorate has further explained that it has searched 46 premises, issued 13 POs, and has attached 204 properties valuing 12,012.45 crores. Main paragraph. That's right. Having gone through the counter affidavit of the Enforcement Directorate, it appears to us that the aforesaid agency is expected to the aforesaid agency must look into every possible financial transaction suspected to be which might have led to siphoning of the funds and determine the estimated value of the proceeds of crime. In this regard, the Enforcement Directorate is well advised to constitute a special investigation team comprising its senior officers and take all lawful measures to take the ongoing investigation to a logical conclusion. It may not be appropriate for us to express any opinion at this stage, except to observe that there has been an unexplained delay. There has been an unexplained delay on the part of the investigative, on the part of the ED.
I'm for both.
ऐसे तो यहाँ तो दोनों का इकट्ठा लिख दो यहाँ पर ऐसे तो similarly a report in sealed cover has been filed by CBI in bracket risk number 3 which has been opened and perused. It seems that a formal FIR was registered on the basis of a complaint received from State Bank of India. According to CBI, the complaints received from other banks stroke financial institutions are also being investigated by enlarging the scope of the said FIR. Such a report adopted by CBI, apparently, does not seem to be in conformity with the procedural law, as is complaint, even if it pertains to defalcating of public funds, is based upon its own unique set of facts and therefore would constitute an independent offense.
Also touch upon 17A. Also touch.
Furthermore, it is imperative on the CBI to investigate the conduct of the bank authorities as to whether the financial assistance was released from collusion and connivance with the management of the companies in default. In this vein, the reference by CBI to Section 17A of the PC Act is totally misconceived. We direct that regardless of any such provision, the CBI must look into the nexus, stroke collusion, stroke connivance, stroke conspiracy, if any, and for that purpose, all lawful measures for taking the investigation to its logical conclusion be adopted. Next paragraph. We may hasten to add that both agencies, namely ED and CBI, have already taken their own time in springing into action and any other further delay will not bring, and the further delay put it in a positive way. And we therefore expect that both agencies will act promptly, independently, fairly, and in a dispassionate manner as well. Let status reports by both the agencies be filed within 4 weeks. Post the matter for further consideration on so and so date.
Only
One last thing.
One small request, only.
Since
Mr.
your
Bhushan.
lordship is now monitoring this matter, there is now serious apprehension that the owner of all these companies, my lord, the person who owned these companies, he may flee the country. Now, they have not arrested him. They have
Why
not
should you
even
make
issued
that
a
statement?
lookout circular.
I am in India, I am
They
before the
have
court,
not even
I am not
issued a
running
lookout
away, I
circular,
am not going anywhere.
which will prevent him from fleeing the country. So many people, my lord, with tens of thousands of crores outstanding have fled the country.
There is an
At
LOC
least-
against him, my lord.
There are several LOCs. I have not gone. I have not attempted to go. I am, my lord, working in my office in these companies even today.
That I think that having been issued, they can't do now.
And I am not going, my lord. There is no question.
Lookout order.
Lookout
Issue a
circulars are
lookout
issued.
circular.
There are several of them, not one.
They can't allow him to flee the country. At
Arre
least
bhai-
a lookout circular, even if they are.
Why is
not-
my friend making this statement, my lord? Is there any material to say that I have fled the country or have fled the country?
You have.
We have repaid 20,000 crores in the last 3 years. If I had to go, I would have fled earlier. Not now. Why do you make this kind of statement?
Now
Just because of the press?
Because the court is monitoring the matter now. That's why I'm saying.
So where is the?
That's why.
Show me one one shred of evidence to suggest, my lord, that this man is running away.
Solicitor General, you, whatever necessary steps are required, because we do not want anything to happen which may frustrate the ongoing investigation.
I understand.
You must
A
take-
line from your lordship, my lord, would really.
We must take whatever preventive or other measures are required to be taken. We do not want that investigations are hampered at any cost.
Observation करने के लिए सब सिद्ध हो रहा है.
My lord, statement, I will not leave the country without the leave of the court. What more is required? Just to make, my lord, allegations against us?
My lord, only a minute, only a minute. My lord,
At this
my lord, there is something I want to say at this stage.
Mr. Prashant Bhushan, Land Counsel for the petition.
R5, my lord.
My lord, before your lordship dictates, my lord, one thing. My lord, I respect Mr. Rodgi's statement. But in past, my lord, he has also burnt his fingers. He made a similar statement in favor of one of the clients, my lord, before Delhi High Court, and the person did flee. I'm not saying, my lord, about this person.
But he came back and he paid 5,000 crores to this government. Let's be
But
very clear.
after 5-6
Once
years, but
he-
sometimes,
once he-
my lord, statement becomes, my lord, embarrassing for the
Once
counsel.
he is out of the country, what good is a statement? Once he leaves,
My lord, then there is no reason to trust anybody. Then there should be no revised statement should be recorded about anything.
in a
What
matter
is this
of
kind of argument?
time.
What we will
My lord,
say at
one
this-
will flee
at
after
this
the
stage-
statement for if
At
100
this stage,
people.
Mr. Prashant Bhushan, Land Counsel for the petitioner states that,
Very, very unfair.
that
Make these allegations.
owing to the
He is responding.
alleged, owing to the amount of alleged fraud involved and the action now and the matter having, being investigated under the supervision of this court, there is every likelihood of the principal accused being from country. On this, Mr. Mukul Rothgil and Senior Counsel representing respondent 5
Yes, sir.
states that that his client will not leave the country without prior permission of
Of this court.
without prior permission of this court. Full stop. Mr. Solicitor General of India assures that all remedial actions,
Preventive actions.
preventive
Preventive.
and remedial actions will be taken to ensure that no impediment is caused in the ongoing investigation.
Yes, certainly.
That's fine.
Because the
I'm
other,
grateful, my lord.
because we haven't had the advantage, of course, of these sealed envelopes. We really don't know
They are
what is in it.
pending
We
investigations.
know this a bit about the affidavit which the Enforcement Directorate has filed. So, my lord, your lordship may give us 3 weeks because at this stage,
4 weeks we are done
yes, for a counter affidavit.
for counter.
Yes. Please do that because this is on denials. We are denying these allegations fully, my lord, because otherwise the court ultimately is
We are
going
not
to the
taking-
appellate remedy.
That's why we are very careful in
Yes, your
using
lordship.
the word.
No, but we have seen them.
And
That-
we are also granting you time. 4 weeks.
Absolutely.
I'm grateful.
Obliged to.
Lord, kindly come to page number 63, my lord. Lord, 2 years after construction of the overhead tank, kindly come to page 63, my lord.
Commercial loans are provided with the bank. And I have paid everything. I have got no due certificate.
63, my lord. Lord, we had constructed a overhead tank, my lord, for the people of this Ilayangudi village. And my lord, we are
The water tank.
a water tank. And my lord, a small panchayat office is there. My lord, on a land, my lord, disused land, my lord, which was originally, my lord, a village pond and later classified as, my lord, a disused land. My lord, in fact, we have an hydrological report also saying this construction will not anyway affect in the other part of the land, my lord, which is retained still as a pond. My lord, the High Court, my lord, directs us, my lord, to remove, calling it as an encroachment. My lord. And thousands of, my lord, yes, my lord.
And water tanks. Completely.
And 3,000 direct beneficiaries of this water. My lord, fresh matter, my lord, coming for some delay also is there.
Delay condone, issue notice returnable on so and so date. Meanwhile, operation of the interim judgment of the High Court shall remain still.
Lord, R1 is the writ petitioner, others and all were respondents, my lord, along with the former councillors and all.
So notice returnable on so and so date. और जो है डिले भी उनको सुनकर के कर दे तो ज्यादा रिव्यू इज 107 days.
हाँ, जब ज्यादा नहीं है उसके बाद
And bill 380. 900. Returnable on so and so date.
Stay, my lord.
Number 1 being the contesting respondent, comma, the service on pro forma respondents is dispensed with. Respondent number 1 may be served through dusty notice also. Meanwhile, operation of the interim judgment and order of the High Court shall remain stay. Consequently, the water tank, there shall be no demolition of the Panchayat Bhavan or the water tank.
Grateful to you, lord.
Hey, this is another interesting kind of bank fraud. It's, if every day, my lord, they come out with unique,
objection for saying this.
unique ways.
Absolutely.
Question हुआ था, दो questions.
Your lordship should see how a genuine transaction is put into so much of court pressure. We should give us 2 minutes, my lord.
I appear for.
Genuine commercial bank transaction put into so much of pressure and anguish, my lord. Please see the number. We have recovered 116% of the loan amount. And now he wants an inquiry. Absolutely a roving inquiry without any basis. Please see the numbers.
They are so worried that they don't.
No way.
No, this kind of slings in the dark. What the High Court says.
Bhushan, you have also to understand that this is a commercial transaction where the ledger value has already been
Recovered and more.
to the auction. Then
No, my lord, ledger value has not been recovered.
that's the finding, sir.
No, the company itself says that they have made a profit of so and so because
Oh,
it's one-time settlement. If your lordship now turns to page
Kindly turn to page 30 of the
Actually, my lord,
record.
at page,
Page 30.
we have analyzed at page 189, what was due and what has been recovered. By the, if your lo-
Come to page 9, 7.2. It
Yes,
is
7.2.
116% of the
Please,
lending.
I got the calculations. Lordship may see the
that is,
calculations.
on- that,
This is not trouble.
that is only the principal amount, not with interest. What was due with interest is, my lord, given at page 189. Otherwise, there would be no need for a
Yes.
one-time settlement. The only reason why they entered into a one-time settlement was because they said, and the bank said that, look, now the property has been devalued from 2,600 crores to 970 crores. Something very astounding. In 2021, my lord, this hotel was valued by the same valuer for the bank at 2,600 crores. 3 years later, in 2024, the same valuer values this same hotel at 970 crores, 1/3 of what he valued 3 years ago.
What was the mode of auctioning?
Mode of, no auction. What they said was,
Two options.
It's a settlement.
what they said was, we will enter into a one-time settlement, and the one-time settlement,
Concept law, comparable, that was wrong. If you have a hotel use, not the value is lesser than a commercial use, that's why it was done. And after I had paid everything and obtained a new use, this petition is filed.
How much was the total loan
Yes, my
liability?
lords may see, my lord, the court has gone into, Lordship may see the sheet of paper,
I'll
only one
just
sheet,
show-
my lord, which we have given to your Lordship.
if your
And
lord,
see the second sheet. Only two sheets were,
Tell us, how much was the,
my lords may see the numbers. Yes, your Lordship may see the numbers. Loan sanctioned is
loan with
242.61 crores.
240?
I have given the sheet, my lord. I have given a sheet of paper with these numbers. Yeah,
Very
please.
good.
Yeah, please.
that was the original
Yes,
loan.
one minute, please, Mr. My lord, loan sanctioned is 242.61 crores. Ledger balance at the time of OTS is 226.54 crores. Total amounts recovered is 414.6 crores. Profit of 172.
No,
It-
Mr. Venkataman. This 242 crore was given in which year?
I'll give the year in a minute. I'll give it in a year in a minute.
March
2015.
20.
2015.
15.
Yes.
Now, out of this principal amount of 242,
They have paid so far, 400, including all the settlement, 414.63, line 3.
that 414 is paid only in OTS.
No. If your Lordship sees the second line, 242 came down to 226 at the time of OTS because interest, always bank takes interest first. So once OTS has been compounded, the total amount recovered by the bank is 414.61 crores. And my lord, the date of declaration of the NPA is 31/12/2020. Bank sanctioned a one-time settlement of 265 crores.
No. This 414 crore is paid when?
No, my lord, since inception, my final payment was made in 20.
Actually, my lord, at a glance, your lordship can see.
What is amount in 2023?
In the COVID period, the hotel was empty. We were declared an NPA.
NPA?
The hotel is empty, it can't pay anything. That's across the
For
country.
3 years.
When they created a default, we challenged it. We said, we are not a default, when the hotel is not, establishment can't.
No. Mr. Rotgi, if the account is declared NPA
Yeah.
and the assets of the borrower are valuing more than what the total due amount, in that case, normally, what these bank people do, they always go for auction. They don't allow a poor resident.
No, we exercised the option twice.
100 square yard house, they will throw him out, will put him in auction because
We went for auction twice and it failed. We have exercised that option. It's not that bank has not done it and it failed.
We questioned it. In COVID, the hotel was empty. We were suffering a loss of 100 crores. Lord.
किसी गरीब आदमी को ना,
And my lord, please see
Prior to COVID,
on the valuation.
1 minute.
prior to COVID, we were fine.
It's there.
COVID did not created a problem for all kinds of luxury establishments like hotels. We were questioning our NPA. Finally, my lord, this was the figure which was being.
No, but this unfortunately settlement is in 2025.
Now, yes.
2024.
So before, in 2025, on 24th January 2025,
Yeah.
before that, when did you put the hotel for auction?
Yes, for 2 days. We have done it twice and it failed. We'll give the dates. Twice we have done the auction, we'll give the date. Asset reconstruction auction will not took place in 2 dates. Lord,
2023.
P6 and P5, my lord. P5 and P6. One is, my lord, dated.
कहाँ है print?
It happened in 2020.
2023. Yes, yes.
Office bench के लिए है. बीच में पूर्ण आपके 100 marked है. हम Paris mark के साथ.
5/9/2023 and my lord, 29/11/2020.
No, no, 5/9/2023, what was the highest bid?
No bid was received in both.
After, then, in 5/1993, first of all, please show us the records of the auction. Please produce the record of the auction.
We'll do that. Will you last kindly
After
tell?
1993, 2023, then you are entering into an OTS on 24th January 2025.
Yes.
Even a layman in Delhi can take notice of this fact that what is the value of a five-star hotel in Delhi.
Just
Lord,
see,
there was a moratorium stay for
Just see-
3 years
just see
because of COVID.
page-
So, my lord,
That 3 years is
High
over.
Court, because of a High Court order.
if your lordship
That
just
3
sees,
years is over when in 2023 you try to auction it. That
Yes.
means that 3-year moratorium period was over.
Yes, yes.
Now from 23 to 25, when anybody on the earth can take judicial notice of this fact that the value of real estate properties are rising, and you have a 5 or 7-star hotel here, you enter into an OTS. Before that, you don't make any attempt to auction it.
But we have done it. My lord, with great, there are 2 facts have not, well, the High Court has recorded 2 facts. My lord,
So
2,
please produce the records of the auction. We would like to see it.
yes.
Your Lordship, just 1 second.
In fact, my lord, if your lordship turns to page 252, just turn to page 252.
my lord, nobody
is-
can then come enter into a
Just
commercial understanding of an
page
OTS.
252.
When, my lord, in IBC process, 90%, this is a case of a recovery of 116%. Your lordship is now, my lord, to say that this should be,
As a matter of principle, in the commercial wisdom of the banks or the financial institutions, we will not interfere. There is no question of it. But when we are talking of your commercial wisdom,
yes,
we also know it very well that you are not a private entity.
no doubt,
The funds which you have are the public funds.
no doubt, my lord.
These are this money belong to the people of this country.
Yes.
Therefore, your commercial wisdom is for the purpose of giving undue benefit to a person, or it is to protect the public interest.
Which is not
That
their
part will
case.
have to be investigated.
Greatest respect. My lord, today, the case of the petitioner is a roving inquiry. He doesn't make out any case.
We are not concerned about the petition.
Yes, answerable to the court.
We will go to the extent that the petitioner has been planted by some rival. Somebody who wanted to buy the hotel couldn't buy. Let us take it like that, worst part. But now that a fact has been brought to the notice of the court,
Yes.
we should satisfy our conscience that the things have taken place in a transparent
Yes.
and fair manner.
Lord, which is what the court has said.
If your
We'll take the
lordship
findings of the court, my lord. But finding after finding,
just sees one page,
Hotel was not, my lord, having any default prior to COVID. It suffered a default. The government of India, my lord, also issued circulars in regard to this period of default. If I have come out of it, they did try to sell. After that, I am back on my feet and I have paid. Is it a case?
Mr. Rotgi, we have no difficulty. Every day in, day out, in matters before us,
Yeah.
the plea taken by these very banks is, we will not enter into any OTS because the value mortgaged by them is much more than my loan amount. Therefore, why should I go into OTS? This is the consistent stand they take before us. That we are not going to accept any OTS because we have an asset, we will auction it and we will recover entire amount.
But, my lord, is it appropriate that a man who suffers, my lord, great losses during COVID, not a single room in the hotel, my lord, was functioning?
No, we are talking of, had this settlement been in 2020,
Yeah.
things would have been different. This settlement is taking place in 2025. This OTS is in 2025,
Yeah.
when the entire, hospitality sector, the hotel, they are flourishing.
Yeah.
They have wonderful business, each one of them making money. A 5-star hotel in Delhi has its own value. People know it very well. Who is going in the street, who is going to believe it that this hotel has a value of 300, 400 crores? When the value
It's
might be
not-
4,000, 5,000 crores?
It's not, four valuation reports are on.
It was only 200.
Four.
The debt was 200,
Fine.
250. It is settled at 400.
Why
Therefore, two things, let them produce. First, produce your ledger books that if going by the rate of interest and all, as per the original loan agreement, what was the total amount as on 24th January 2025?
We shall not, a special committee comprising of a retired judge and four other bank has come, but this OTS was decided ultimately not by the bank alone. It had 5 people in the committee headed by a retired judge, which decided what should be the OTS amount.
Then immediately produce this report. We would like to see the report of that learned retired judge also.
No,
Please produce that report.
I just want to make one small request, Your Lordship. I'm appearing for the bank. The committee consisted of 5 persons, a RBI nominee, a Government of India nominee.
If your lordship just sees,
Besides the bank official, there's a RBI nominee, a Government of India nominee, and a shareholder nominee. They were all independent persons who had nothing to do with the banks playing any fraud in this case.
No.
And it kindly, therefore,
We have no doubt about their independence, Mr. Attorney. This all depends on what the facts are.
Your Lordship's question is certainly well placed, but the question is,
It is something like whatever in a writ petition or in counter affidavit is brought before us. Based upon that set of facts, we take a view. Our view, despite the fact that nobody will question our bona fide, nobody will question our independence, but still our view can be erroneous.
certainly we go by that.
It's not brought on
We
report.
certainly go by that proposition, but the High Court said, I've looked into all these aspects.
Yes.
High Court goes into an independent of the settlement committee. High Court says at 12:30, I
These are
don't
detail-
find these are roving inquiries
Yes.
for no good reason.
Absolutely a non-serious,
So,
my lord, non-serious, vague, bald, sweeping allegation on, my lord, a bank, on a my lord, we are not defending every transaction. We ourselves come. But, my lord, to say that therefore every transaction has to be, my lord, 5 million transactions happen every day. If you are going to put, my lord, a spokes to, my lord, through a process to say that this should, my lord,
Mr. Venkatraman, unfortunately, we are not saying that every transaction, but many of the transactions.
Certainly, my lord,
taking place,
we
and
are.
particularly
Why that?
under this, the direct or indirect umbrella of this IBC.
Yes, yes, my lord.
These have become a very doubtful manner. A poor lady, a widow woman came to this court. She was before us with tears in her eyes. She wanted to pay 30 lakhs to a bank. They refused because they wanted to 46 lakh. She lost her husband. That's why the default was committed. We had to come to her rescue only to protect her residential house. When question of their case, they said, no. The value of the house is more than 50 lakhs. We have to recover only 46 lakhs. Why we should enter into OTS? This is the stand these commercial wisdom people take before us. And when the question of a 7-star hotel comes, the stand is altogether different. Why our conscience will not click? Why should we accept it?
May I only persuade on one aspect?
Please produce the record. I would like to satisfy myself.
Your Lordship will do that. I only want.
So will be my brother. Let the original reports of
The settlement.
the bank, complete details of the loan amount which was due as on 24th January 2025, the report of an independent valuer, if any, assessing the
Four valued will be produced.
market value of the hotel as on 31st December 2024, that is immediate before OTS, and other relevant reports be produced.
Well, there are 4 valuation reports converging on value, except for the one odd value report, which said, well, this is a hotel. We can't sell a hotel. Well, valuation demands, hotel cannot be sold as some industry. One odd valuer gives a report of 2,000 crores, which my friend is relying upon, who says it's a commercial property. It's one whole building is left out from the loan. Loan is not, ultimately the mortgage is only limited to a few sections of the whole. He values the whole as commercial, contrary to 4 bank authentic valuers who all confirm what this value of this hotel would be at a given point of time. 4 concurrent valuation reports. Well, the High Court spent a lot of time. Well, we'll certainly persuade your Lordship. No difficulty. But only thing, my Lord.
We have recently, incidentally before my bench only, We have dealt with the auctioning of 2 hotels in Kerala. We have seen the people come forward to buy hotels also. There is absolutely, it's not that people, the prospective buyers are not available.
We have no difficulty in producing.
Understandable. Suppose you say that I have tried my best in December 2024. I could not auction it. I did not get a single bid. And therefore I had no choice but to go for OTS. We will accept it.
That's precisely
That
what
is
happened.
commercial wisdom.
Precisely what has happened.
Not even otherwise.
We will produce the records.
In that lot of
We'll produce the records.
Just see one page, my lord.
Which I suffered in
Page
COVID.
252.
Why should the hotel be sold? Apart from that,
we are not saying.
it's not that I was not a default.
If a borrower,
Siphoning-
Mr. Rotgi, if a borrower, small or big,
Yeah.
if he can save his mortgage property by paying to the bank a reasonable amount, no difficulty.
Correct.
But not in this manner. If at all, it seems to be.
I think, Lord, your Lordship will be satisfied on the manner. Lord, I'm sorry, but your Lordship will be satisfied. I think, Lord, this,
Yes,
Lord, this is an
I would never
litigant who
stand
is
for
just
it, Lord.
going hammer and tongs. We'll
We'll show
satisfy your
anything. There's no
Lordship.
difficulty. We'll show it, my Lord.
Just-
Absolutely
just
no
see
problem.
One page.
Lord, the
page
other issue will be,
252
can you really upset
of the
TSs
paper
which are done in this manner?
When complete contrast cases come before us, we get disturbed only because we do not know what's happening.
Absolutely. There we are with your Lordships.
But your Lordship will be satisfied.
We'll have to cut the oranges from the apples, certainly.
OTSs are happening in this country. If not
Yes,
every
yes.
matter is.
Lord, we say this with a sense of responsibility. An extremely genuine OTS transaction is what has been brought unnecessarily into scanner. That statement we will make it to
Say
the.
notice to respond number 4 and 5, 4 to 6 only at this stage. Number 1, notice to respond number 1, 4 to 6, and 4 to 6 at this stage. Then also report will be produced.
Yeah.
This is up to.
Therefore,
I am obliged.
Oblige your Lordships.
Ah, chal.
BMW But office report shows on 4 earlier occasions SLP is dismissed.
May I just place my matter? I'll place all of that. I'll place that. I'm for the petitioner. This is a writ. The only question I'm pressing in this writ is my prayer A. What is happening? I'm not seeking any relief in respect of the matter, which is prayer B. The only relief is prayer A. Your lordships will have at page 17. What is happening in the state of Telangana, my lords, is
Mr. Prasad, how many times your petitions will be entertained?
no writ petition. Plus, what has happened is page 237, your lordships, I had come up in a SLP all the way, and at page 237 is that order where the liberty was given. My lords, just hear me for 1 minute. I see that, my lords, I have come in a SLP. Let me explain that, and the liberty was given at page 237. Your lordships will have that order.
File SLP. Please see the order.
Yes. My lords, page 237 is the SLP. And my lords,
And you file another SLP challenging this.
no, my lords, I have filed only one SLP that was knocked out on the point of delay. The question was never considered. That came before Justice Narasimha's bench. The bench observed that earlier order. Yes.
Mr. Prasad, then
Yes,
that means if we dismiss the SLP, we decline to entertain SLP.
Yes.
According to you, the second SLP is maintainable.
No, this is a writ petition. This is a writ. Well, the court indicated that please, we are not going to, because against the same, against the same order, the question, only the legal question, because in the state of Telangana, well, the court indicated that if you have to move, please move a writ. That's why they gave me a liberty. I am not seeking any relief in respect of this matter, but what's happening in Telangana, your lordships will just consider one thing, my lords. What's happening is reserved candidates are being counted if they are meritorious against general seats. So, my lords, which is incorrect, because the law is very well settled. If I on my own merit make it in the general, then it has to be treated as I am.
SLP, please.
The SLP was dismissed on the ground of delay. So the High Court also didn't engage with this issue. The court at page 237, that's the order I had myself appeared, indicated we can't engage in this because I have dismissed an earlier order, earlier SLP against the same matter by some other party. Therefore, if you have to file a writ. That is why the liberty was given at page 237. And pursuant to that, I am filing. I am not seeking any relief or stoppage of the process here. I am only saying my laws will settle the law so that for future there is no problem in Telangana. That's the only prayer. This your lordships may not interfere. My laws may record my submission straight away. I am not seeking interference with this process now. Because otherwise every year this will be happening, my lords.
Thank you very much. We will not entertain this.
All right, my lords.
The petitioner has already lost the first round of litigation up to this court with dismissal of SLP civil number 16170/2025. So we are just of the view that the second round to this petition is wholly misconceived, misdirected, and not maintainable. Dismiss.
Great. Because I'm for the petitioner, my lord. These are two matters, my lord. My lord, similar matters have been decided, my lord.
But these are fresh matters.
My lord, these are fresh matters.
Fresh. Any matter already pending where we can tag?
My lords, as per the office report, no, my lords.
Issue notice, trustee, liberty to serve the state through standing conflict.
Most grateful, your lords.
In the earlier notice, recommendation. Item 6. Already dismissed.
Please, your lordship. Lordship, this particular matter, as per the office report, this is already.
Similar matters have already been dismissed.
Yes, your lordship.
Same order. Item 7.
Wait, please, lordship. Well, I've just set out these, and just see the pleadings. Well, just see the pleadings against defendant number 17. I've just put them Just hand that up. I've handed it. My lords may just see this. Look, I've just summarized, I've set out the pleadings against 17. Just see that for a moment.
Apply Order 1, Rule 10, discretionary relief. Why?
Order 1, Rule 10 2, but just see the pleadings here. Just see that for a moment. This is not, it's a case which...
A case cannot be maintained against a shareholder when the cause of action is against the company. That is your argument.
No, but there's nothing against the shareholder. Just see the pleading. Ultimately, even against the shareholder, there should be some pleading. Just see that pleading for a moment. Give me, just indulge me. I'm not asking your lordship to open the papers. I've set it out here. Just let me read that, lords. I've set out in extenso. I've reproduced it exactly. Just see, my lords. The solitary pleadings in the plaint with regard to D17, plaint is from 38 to 107. It's a 90-page plaint. Para 18, the 15th to 19th and 21 to 28 defendants are shareholders of first defendant and are therefore beneficiaries of the trades done by first defendant on the plaintiff's exchange. Para 91, the plaintiffs state that in view of the fraud and default committed by the defendants are jointly and severally liable to pay the outstanding amount with interest in respect of the said outstanding trades to the plaintiff. Para 111, the plaintiff therefore submits that this is an eminently fit case to secure the claim of plaintiff by attachment of all the assets of so-and-so defendants, since the liability of first defendant admitted by them runs into hundreds of crores of rupees, and the defendants are consistent with an intention to defeat and defraud the claim, which is manifestly evident by the act of restricting inspection of exchange designated warehouses. Para prayer is, this honorable court be pleased to pass a decree and order directing first, third to 41st and 45th to 50th defendant to jointly and severally pay 937 crores. Now, they relied before the High Court on this para 87. Just see overleaf. Para 87. The High Court just merely sets out the para. Just see para 87. It is pertinent to mention that from September 2009, when the first defendant commenced trading on plaintiff exchange, till August 2013, the management and the affairs of first defendant was run by the 6th and 7th defendant. In fact, 6th and 7th defendants were actively involved in the transactions entered into by first defendant on plaintiff exchange. The entire conspiracy to defraud the plaintiff exchange was conceived of and orchestrated by 6th and 7th defendants. It appears that the companies owned by 6th and or 7th defendants and other companies firm, which in turn were owned by individuals who are related or connected to 6th and 7th defendants, benefited from or participated in the fraud. The directors, shareholders of first to fourth defendants are either family members of 6th and 7th defendants and or people accustomed to acting on instruction. I'm not a director. My father
was a director.
He resigned in 2013. Suit is filed in 2021. 8 years after he resigned as a director. No averment against my father.
Roman 9, clause 9, Roman 9 of paragraph 87, that the shareholders are in collusion with the directors in respect of the fraud.
I'm not a shareholder.
You are a shareholder.
I'm sorry.
Paragraph 80.
It's a public limited company.
I'm a shareholder of the company. Your plea for dismissal is no dividends have been declared, so there is no...
I'm sorry, my lords. Please just see the law laid down by your lordships. This is a... This opens
the law laid down by us is not to substitute a discretionary order.
No, this is not a discretionary order with respect.
Absolute discretion.
Not 711 lies even with regard to if the entire plane can be rejected against one defendant.
Don't make advance arguments on 711.
Your lordship.
Your prayer is under Order 1, Rule 10.
And under 711.
711A. If you argue on 711, you are out of court.
Lords, your lordships
cause of action is made out. Simple.
I'm not just see. I've set out the judgments also in this note. I'll tell you what. In Church of Christ, your lordships have categorically held that even with regard to an individual defendant, if the entire plaint can be rejected, 711 lies. Now there is no cause of action shown against me. Just making a bold statement.
Can entire plaint be rejected?
I'm sorry, Mlad.
Can entire plaint be rejected when there is an allegation of fraud against...
Entire plaint has to be rejected. There's no allegation of fraud against me.
Doesn't matter. For that, what's the remedy?
No, there has to be some basis.
Order 1, Rule 10(2) will make your defendant a party, a misjoinder. So for that, it's the discretion of the judge to keep him as a proper party. Simple.
No, I'm saying your lordships have said that just by some artful pleading, look at the nature of the pleadings here. With this nature of pleading, every shareholder of every company will.
Mr. Singh, please come to page 26, opening line of ground C.
Page 26, Milord.
Page 26, opening line of ground number C.
I'm sorry, just give me a moment, Milord. Ground C, the High Court failed to appreciate that in these circumstances, the petitioner only being a shareholder of. Yes, I'm a shareholder of defendant number one. The description is only that I'm a shareholder, nothing else. Which means in every claim against a company, lakhs of shareholders can be roped in as defendants.
We agree with you. He is not a necessary party, but he can always be treated as a proper party.
But there should some averment against a party. I can understand if there was an averment that apart from being a shareholder, I have in some manner done some act, any act, even one act. There's nothing here, not a whisper.
No, sir. Where is your most respected father in these days?
I'm sorry, Milord.
Where is your most respected father in these days? The whole country is eagerly waiting for red carpeting for him.
Look, only one thing, look, then let it be clarified that I can only be a proper party. Now, here, please see, if there's no absolute absence of any averment, not a single averment against a party, Milord.
Not a case where we will.
Please, the Lordships.
Appeal for the petitioner, my lord. Lord,
Yes, I to meet.
Yes. Lord, without hearing me on the first day, my lord, and then I've got everything. Environmental clearance, consent to operate.
Approach the High Court.
No, I tell your lordships, my lord. They've passed this order, and now the next date is April. Running, my lord. I know the stone crusher, the moment you hear it, everybody nowadays has a prejudice. But then, my lord, for 3 months, I'm a small entity. I opened in December.
April, so you can request the.
They've just, I had lots to say without hearing me. At least issue notice to me, my lord.
Therefore, if you have not been heard, please go and apply to the High Court. We will make some observations. You can approach the High Court.
My lord, may I just, my normal course, I should be.
Approved by an interlocutory injunction order passed against it by a division bench of the Uttarakhand High Court. Interlocutory order dated 7th January 2026 passed by a division bench of the Uttarakhand High Court. One of the grievances is that the order has been passed without even hearing the petitioner. So since the High Court is now opening after the winter break on 9th February 2026, first we say like this, it seems to us that the appropriate recourse for the petitioner would be to approach the High Court to appropriate applications for its impleadment as a party respondent, semicolon, to seek vacation / modification of the interim order, and to bring on record the set of facts which the petitioner wishes to, set of facts on the basis which the petitioner claims that the Song SAUNG, Song River, is a non-perennial river.
Can I just, sorry.
Since the High Court is opening after winter break on 9th February 2026, we request the High Court to entertain these applications and pass appropriate orders by preponing the next date of hearing. For the liberty of formation, especially petition disposed of.
Can I just say one thing? I don't want to interrupt a lot. My submission is that the relevant stretch of the Song River is non-perennial. That is the permission. Lordship, that Song Rivers, that is not my contention. I have produced documents. The document which they gave, the they gave is the reach of the Song River near Sankatiawala Kala is non-perennial. That is my contention. Lordship may say relevant stretch of the Song River. That is my contention. My contention, even when I file a reply, is not, nobody can say the Song River is perennial or non-perennial. The relevant stretch, it's a huge river. This stretch, which is what the permission is given, the joint inspection report is on record, in which
your contention that you are away from the prohibited area of banks.
Sorry, my lord, sorry.
He's saying that the place where he's.
So, Lordship is relevant stretch of the Song River. That's
Claims and to non-perennial that the site where the petitioners stone crusher, you have stone crusher.
Stone crusher.
Stone crusher is operational. The Song River at that near to that site is non-perennial.
Yes. I won't say anything further. I won't read. Lordship may read annexure P10, how this order came to be passed. I won't say anything.
Perennial and at one point the river is either perennial or non-perennial.
Lordship may see annexure P10. I won't say anything. Lordship may just read it. It was supposed to be listed along with a writ petition against my rival the next day. From this matter suddenly gets detagged and get listed. I won't say anything further. P10, Lordship may kindly see. I won't say anything further.
Anyway, we have requested the High Court to prepone the date and hear you.
No,
You apply immediately and get a
the consequences are grave. On one day, without hearing a crusher stopped, the small entity, the whole.
Mr. Vasan, these are environment issues. Precautionary principle guides the area.
With natural justice,
right?
Without natural.
So, a precautionary principle, when there is an RTI report, the website of the irrigation department shows it as a perennial stretch.
Which is why hearing us, and I've given a perspective. Anyway, Lordship has given me that liberty. I will
lost sight of facts.
I'll leave it. But oblige.
There are two matters before your Lordship, 9 and 9.1. In a similar matter, Lordship, at page 212, lecture P6.
2013 का date में.
Same order.
Double 6/20.
Mallards, we represent Ghaziabad Development Authority.
They are here.
I will respond in 4 and respond in 3. The matter is coming out on 23rd of February.
Respond number 4 only or respond number?
4 in 9, we are 4, and in 9.1, we are 3. Respond.
Accept notice on behalf of the sponsor respondent. Counter affidavit can be filed before 23rd February 26.
Please.
That they will decide all.
Please, oblige.
Can? No. There is a letter. Item 10, there is a letter circulated.
May I please? This is the third time, my lord, the petitioner has been deboarded forcibly and illegally by the MP police and the RPF with the RPF police. This is the third time this incident happened, my lord. He was not permitted to travel beyond his origination.
So what can we do?
My lord, this is the
how do we examine these facts that you were dropped on the way?
My lord, I have filed the documents, my lord, that police himself given that letter saying that we are deboarding you due to prevailing.
You don't have a place of protest in your state.
My lord, this is the case, my lord, where
No, you have a right.
Assured, my lord.
You see, we are not curtailing your right. You have a right to protest.
Yes, ma'am.
Peaceful protest.
My venue is not MP. It is the venue of Delhi.
Yes.
My venue is not MP. In the midway, we were.
Mr. Consul, have you applied to Delhi government authorities?
Yes, my lord, that letter I have annexed.
Yes.
There's no reply. Kindly see the letter which I annexed. 4th of October, I applied for letter. I gave a letter.
Letter you gave, have you obtained permission?
Permission. No reply has come.
If no reply have come, that does not mean the permission has been granted.
Well, even Lordship presume that even no reply has come after the representation is given, that means there is no grievance for conducting dharna at Delhi.
If you are ready to listen to us, then you please appreciate.
Yes, ma'am.
There is an earmarked dedicated place for conducting peaceful protests.
Yes, ma'am.
There you can have a political rally, you can have a non-political rally, you can have the farmers as whom you are saying that you represent. The farmers can come there, they can protest for their demands, whatever. That's a part of the democratic process, no difficulty.
Yes, ma'am.
And for that, there is an earmarked place.
Yes, ma'am.
So first go to that competent authority, apply and obtain the permission.
When I gave a letter, my lord, letter, there is no reply.
The
When I even the lordship say that I have to apply before the competent authority, I gave a letter. Even if the letter has to be given in person, I have to come to Delhi at least.
Yes.
But even half of the way, I was deboarded.
How have you has he engaged you?
Pardon, my lord?
How has he engaged you?
My lord, he is from same place.
So for the purpose of Wakaltanama, for
No, my
purpose
lord, this is not the way, my lord. Kindly see this. There is a violation, a gross violation of 19(1)D and 19(1)A.
like to answer any question which we are asking you.
My lord, I am saying, my lord.
How did he come to sign your Wakaltanama and papers?
My lord, as a counsel, I have to sign it, my lord, that I filed a writ petition on his behalf.
You are filing without any Wakaltanama?
No, Vakalatnama I filed, my
Is
lord.
there?
Yes, my lord.
So he came to sign your Wakaltanama?
No, he sent it by post, my lord.
Oh, he sent it from there. Now he has authorized you. Why can't you apply?
My lord, it is duly notarized by the local notary public.
Very good. So he has sent it. Now you are his authorized representative. Not
I send it, then you will reply. That's why my submission.
go and apply, please. Ask your clerk, you can apply online nowadays. You don't know to, even you are not required to go.
My lord, I am not saying, my lord, because the question is that the appreciation has been given. No reply has come.
Well, thank you.
Thereafter,
Thank you. No case to interfere with you.
my lord, at least, my lord, kindly see, my lord, the last date,
No case to entertain this writ petition is vague. So here look, the writ petition is completely vague, evasive, and full of misdirected governments. The same cannot be entertained, dismissed. Role 5. Writ petition are dismissed.
Earlier, my lord, I was given permission to go to the High Court, my lord. I applied for the High Court, I filed a writ petition. There also they said we have no jurisdiction to entertain because you were deboarded MP.
No, but your standard does not permit to go to High Court. You are not, your standard is not less than Supreme Court. So you are rightly come to
High Court. High Court order also annexed, my lord. After that, my lord, after dismissal of the writ petition, I went to the High Court.
All right, thank
I pleaded before the High Court. Thank you very much. We have no jurisdiction to stop anybody from MP other than beyond jurisdiction of Madras. That is the reason I come before Lord.
All right, thank you very much. Next, item 12.
Lordship, I apologize in this matter. I'm sorry I couldn't circulate letter on time. Mr. Sibbal, who's leading me, he's unwell. So he asked me to make a request. I got information very late. I tried to circulate, but I had surpassed the time. So I'm just requesting 1 week adjournment, Lordship. He's not well. I spoke to him. So.
Your monopoly right is expiring when?
Sorry, my lord.
May 2026.
Lordship, the patent will expire in May 2026. But there was an injunction till the time the division bench passed the order. So I'm just requesting for a week adjournment. There was an injunction throughout.
Next week.
Much obliged.
But if your lordship, so far as the SecPers lady is concerned, there is no allegation whatsoever. But please come to P4 at 61. That's the FIR. And if your lordships are kind enough just to see para 7 at page number 67. Apart from the invocation of 420, 406, etc. together, my lord, just come to para 7. Complainant, may I place it? May I place it?
Para 17 of?
Para 7 of the FIR, Lord, it said FIR will begin at page number 61. I would like your lordship to see para 7.
Yes.
The complainant ultimately advanced large sums totaling multiple millions of dollars, but as market conditions surged, accused persons began dealing, eventually ceasing delivery. So the whole issue is not, it's really a commercial transaction that we could not deliver because of change of market conditions. Others are surplusage and nothing against the lady, Lord. Nothing whatsoever against the second respondent in the entire FIR. Nothing incriminating. She's just been roped in because of relationship, Lord.
What is the stage of the investigation?
Lord, I must tell you, Lordship, I stated, Lord, Charge sheet has been filed.
Let it be investigated.
No, my lord, no. May I just say this? My lord, charge sheet has been filed in the interim while the matter was pending in the High Court. Charge sheet has been filed, but I have not been served a copy of it, my lord. Charge sheet has been filed. It really makes out a civil transaction. I have not been served a copy yet because right now summons have not, process has not been issued. It's a case of not give or take of. Charge sheet was filed, my lord, but we don't have a copy. I can place that on record if your lordship permits.
Appear before the charge sheet has been filed, then go and.
I'm sorry, my lord?
If charge sheet has been filed, then go and seek your discharge as per law.
Not, I leave it to your lordship, but not purely a commercial matter where they say it's only a question of delay.
Commercial law depends upon that initially what were intentions. If your intentions were right from the very beginning to dupe the investors, then you can't claim it a pure commercial transaction.
There was an MOU, and I must say this, for the second petitioner, there is, not this lady, there is nothing. May I just have a look at that for a moment?
Not a case that we can quest.
Lord, may I just make a request? Lord, may I make a request then? Not the concern, I leave your lordship with one more concern. Lord, I was protected till a certain point of time. Kindly just see.
We know that is only prayer. That will be lengthier. You will be released on bail.
Get full. And we'll take our remedies, Lord.
Absolutely.
Yeah.
The petitioners are aggrieved by the judgment dated 22nd December 2025, passed by the High Court at Calcutta in bracket Port Blair bench, whereby their revision petition seeking question of FIR number 34/2025, dated 13 July 2025, registered at Cyber Crime Police Station, South Andaman, has been dismissed. We have heard Sri Siddharth Luthra and our senior counsel representing the petitioner and record and preview the record. It is fairly admitted that after investigation charge sheet has been filed. That means so, we are not inclined to entertain this petition. The petitioners, if so advised, may move an application for the discharge. Such an application shall be considered by the trial magistrate in accordance with the law. Next paragraph. With a view to enable the petitioners to join the court proceedings, it is directed that the arrest of the petitioner shall remain stayed. Petition number 2. First petitioner company. It is directed that the arrest of petitioner's number. Petitioner is a company, Mr.
Sorry, not?
Petitioner is a company.
Not number 2. Second petition number. Number 2, Latifa Banu.
Petitioners number 2, sir.
And there are second 3 matters, not the other individual petitioners. In
petitioners in SLP criminal number 1790 of 2026 and SLP criminal number 12.
We'll give the name.
825 2026 also shall remain stayed, subject to their surrendering before the trial court within 1 week and furnishing adequate bail bond to the satisfaction of the trial court. Also, the learned magistrate shall be at liberty to impose such other conditions as may be deemed appropriate, as may be deemed appropriate.
But my lord, we make it 2 weeks is all I'm requesting instead of 1 week, because one of them is based here. Flights are sometimes a little problematic. 2.
All right, 2 weeks.
And one request for discharge will not be influenced by the observations, because there are certain observations on merits.
Nothing, Mr.
My lord, there are some observations on merit, men's etc.
Thank you very much. Thank you.
Grateful.
Please, man. My lord.
Description of sentence. Yes, Mr.
Please. My lord, the first round, my lord, the constables came And the ground was that they were simply following the directions of their superiors. Now, my lord, here, they are the advocates, and the advocate was throughout present during the commission of the offense. The High Court records that CCTV is not clear, and therefore his presence is disputed, whereas, my lord, there was a test identification parade in presence of an executive magistrate, and thereafter followed by, my lord, his identification in the court. And, my lord, two, my lord, the High Court records the phone which was found and which was used by this person, my lord. That phone was lost by somebody 6 months back. That's also wrong because it is recovered from him at the time of arrest. Please have a look, my lord, at page. And please see, my lord, he was described as an unidentified person, and it was told in the first complaint that once I see him, I can identify. Therefore, a test identification parade was conducted, my lord. Now, please have a look at para 14, my lord, page 15.
Test identification parade, because the FIR was delayed, was after 4 months of the incident.
My lord, there was an inquiry prior to that. There was an inquiry, my lord, and please see, my lord.
Lawyer's presence was not spelled out in the FIR.
No, my lord, please see. I'll just.
Then he goes to the Home Minister, and then the FIR gets registered in April.
It was.
We understand that.
Please,
there were some influence, etc. But still, then the fact of delay.
Please.
We have to examine the identification in light of the fact of delay between the parties. And admittedly, this person was advising some of your partner.
No, my lord, he was never, my lord. The High Court records that his father was once upon a time an advocate.
Your father was the lawyer of your partner who is a co-accused.
But my lord, he never appeared for me. Please see. Therefore, I'm pointing out. Please see. Please see para page 15, my lord.
Yes.
Para 14, my lords, may have a look.
Necessarily, the point is that in a case where the
my lord, in the first round, my lord, when I pointed out that this may not be treated as a precedent, my lords have clarified in the order that in the peculiar facts and circumstances of the case, where they were constables, simply, my lord, following the directions of their superiors, my lord. Here, my lord, please see the police officers and IPS officers, my lord. The police officers are a former MLA is before my lords, my lord.
The question is, it's a pendency of appeal. But the appeal will be heard, all these.
No, 4 months, 364A, life imprisonment. The evidence is on record. The findings are flawed.
High Court has made a fine distinction between the conspirators.
Therefore,
the superintendent of police has not been granted suspension. Your partner has not been granted suspension. It's the lawyer, the constable, and the former MLA who have been granted suspension.
But there should be the findings can't be, my lord, contrary while granting suspension, my lord, with all due respect. The findings can't be contrary to the record, my lord. Please see, therefore I am pointing out, kindly have 2 pages, my lord. Para 14 at page, my lord, 15. Kindly have a look, my lord.
Yes.
It says, my lord, the applicant was throughout remained present when the act of ransom and kidnapping being made by the police officials. Hence facts remains that the CCTV footage relied upon the prosecution seems to be not as much as clear. My lord, I was there, I identified. And 2, my lord, now please see the second finding.
Mr. can clarify that this observation and nothing should have no bearing on merits. But the point is that once bail has been granted, why?
Lord, yes, I can understand, but this is an offense, my lord. Please appreciate a police officer is posted, my lord, 400 kilometers away. He comes to Gandhinagar from Amreli, and then he abducts. Then there is a transfer of Bitcoin where this MLA is involved. The advocate is present throughout the incident, my lord. Even prior to that, in the conspiracy, my lord. In the conspiracy, right from 7th of February till 11th of February, they were in constant touch. The person who was released, that is Kirit Paladia, and my lord, this MLA and these lawyers were in constant touch, my lord, on phone. Those are CDRs on record. There were meetings in the circuit house, the government circuit house, my lord. That is all, that register is on record.
Question of connecting this entire evidence to establish that there was a a meeting of mind or that there was
But,
a,
my lord, there is no.
a preconceived conspiracy. All these are matter of trial because it's
Therefore,
not
my lord,
a case of
there was a.
substantial evidence.
But, my lord, if the findings, my lord, are prima facie in contradiction to the evidence on record, just kindly have a look, my lord, what the learned judge records, my lord. Only one thing. Here, my lord, the High Court records that, kindly see page 16, my lord. What the High Court has recorded. That the mobile number 816, the last digit, claimed to have lost 6 months back. And then please see page 443. It says there is a finding that further the mobile number so and so recovered from the accused Ketan as per the deposition of so and so. So there was a recovery, the High Court records that it got lost 6 months back. My lord, the findings are prima facie, my lord, in contradiction to the evidence on record. I can understand suspension, but please see, my lord. So at least, my lord,
Assuming it's an erroneous order, even then we should not interfere. Unless we find a complete pervert order going completely beyond jurisdiction, where the High Court.
My lord, this is prima facie in my respectful submission, my lord. Once the High Court records a finding which is contrary to the record, my lord, then what more perversity is required, my lord, with all due respect. And please see.
We have heard counsel for the petitioner.
And two unidentified person, my lord. The High Court records he has not named. I was not actually knowing him. He came in Elantra car, my lord. That Elantra car he borrowed, that witness evidence is there.
The impugned order, that the impugned order pertains to suspension of sentence and grant of bail during pendency of criminal appeal. We are not inclined to appeal with the same. Especially.
And this may not be treated as precedent, my lord. Now the police officers are in line. At least my lords may say that, my lord. They may not get the benefit of parity, my lord. If at all my lords are, my lord, not intervening, my lord, because of the rules, my lord.
It goes without saying that such a prayer, if any made by the who accused who are police officials, shall be dealt with by the High Court as per their own right.
Please.
High Court has already rejected.
14 and 15, my lord. 15 is. No, the other police officers have not come. Only one, and he has withdrawn. My lord, only one. Only one. That is Kirit Paladia. He is not a police officer.
Police.
No, my lord. Superintendent of police. His application is.
No, that has been turned down.
No, it is
the High Court made
the police inspector, my lord. Not the superintendent of police.
The superior police officer, the constable's bail were granted.
Constables were
the
granted.
Superior police officer's bail has been turned down by the High Court.
No, only the police inspector, my lord. One of them.
Inspector.
The SP.
SP is to.
Yes, my lord. Now SP is waiting for
the
house.
inspector is down.
With the addition of this line, they will be taken care of.
Please, my lord. We are grateful.
Came out of 15. Came out.
Please, my lord. My lord, this is a case where petitioner is seeking his right of hearing on the bail application. My lord, what is happening that bail applications are being filed by the litigants, and that is keep on adjourning without taking on the roster because of the heavy roster or any other reason. We have the compilation of इधर से दे दीजिए एक बार ये दिन दे दो My lord, we have the compilation of various cases where such type of practice is being done, my lord. Please, my lord, I have the list. I have prepared on my own. It is not the list of compilation of all such type of cases. But suppose the case is at serial number 3.
Sir, basically, I'm to report. So, there is a slightly unusual prayer made in this special petition. It seems that the petitioner has approached the High Court for grant of regular bail. The petitioner has approached the High Court for grant of regular bail in a case registered under section 115, 190, 191 in bracket 3, 324 in bracket 5, and 351 in bracket 3 of the BNS 2023. The petitioner was arrested in that case on 11th August 2025. In bail application, he approached the High Court for grant of bail and his application came up before the High Court for hearing on 8th December 2025. It was adjourned to 20th February 2026. That is for a period of more than 2 months. The petitioner then applied for preponement, but while impugned order dated 22nd December 25, his prayer has been declined on the ground that the bail application of his co-accused has already been dismissed. Next paragraph. During the course of hearing and on a query by this court, Komal and senior counsel for the petitioner submits that there are numerous bail applications pending in the High Court of Punjab and Haryana at Chandigarh, where matters are adjourned where the dates are being given months after, and as such, the bail applications are not being decided for a long period. On a further query and on an illustrative basis, he has submitted a chart of some of the bail applications which are pending since October 2025 and are currently adjourned to since May 2025 and are currently adjourned to different dates in the month of March 2026. You are for the state?
Yes, Your Worship, I am appearing for state.
Okay. It's not your fault, maybe.
Yes, yes.
Your fault may be that because you might be taking date or you might not be producing the record. But this is not the way the High Court should deal with bail applications. If you don't want to grant bail, you reject it. For 6 months, for 1 year, you don't decide the bail application.
My lord, I have given the suggested measures also, where the state is seeking time for filing status report and on any other, there are various reasons for which the bail applications are being pending. There can be mechanism, my lord, because 7 days time is always given in regular bail in High Court. Within that period, they should file the status report so that it cannot be adjourned. Because once adjourned, then it goes after 3 months.
We had introduced a system there that when you file the bail, we don't know now, you file the bail application, you will give an advance copy in the AG office, and when after a gap of 1 day, the bail will be listed and the IO will remain present in court.
Earlier it was being listed, but now.
Of course, now with the hybrid system, the IO can appear even online, but the bail application could be decided the very third day.
Yes, but now it is listed after 7 days. And even within 7 days, no reply, no status report, no.
And that's why when we ask for the disposal, only these bail application disposal is shown. The regular matters are still pending there. All 1985, 86 RSAs of criminal appeals, everything is pending.
Please, it directly affects the liberty of the litigants.
Next paragraph. ये सारे सर्विसेज से जाते हैं ये क्या इन्होंने लाइफ में कुछ प्रॉब्लम At page 22, you can't blame the judge on a request made by counsel of the by the petitioner.
What is happening in some of the cases, the case is not being taken up. Thereafter, the counsel check the list. Then what is that on the request of the counsel adjourn and status report is awaited. There are also some of the cases. I have given 7-8 suggestions, my lord, how it can be mechanized or improved, madam.
The biggest problem is that there is no orientation, there is no training system, there is no sensitization program of after all they are High Court judges, they must themselves realize it.
My lord, I have given the copy.
क्या लिखा है भाई? ROPs have also been produced in order to show that how the matters are being adjourned repeatedly, how the bail matters are being adjourned repeatedly. Next paragraph. All that we wish to observe at this stage is that we are extremely disappointed to see as how the prayers pertaining to the liberty of individuals are being dealt with. It may be true that the dockets are very heavy and there are other matters which do require prioritization. But amongst the miscellaneous matters, nothing can be more important than the decision of the fate of, nothing can be more important than deciding the fate of the prayer to grant or refuse bail. Next paragraph. We expect Honorable Chief Justice of the High Courts to take some remedial measures. इससे पहले paragraph डारू कर दो. Almost shocking. don't say shocking, say, it is equally disturbing to know that in the Patna High Court, bail applications are not listed even for preliminary hearing for months. And more than 14,000-15,000 matters are pending. One of us, Mera Likho, vividly recollect various matters coming to this court only for seeking direction only for listing of their bail applications before Patna High Court. We have no reason, next paragraph, we have no reason to doubt that Honorable the Chief Justice of the High Courts are cognizant of such prevailing conditions where the High Courts unfortunately are not even able to decide bail applications on time, within a reasonable time. This is happening despite the fact that on occasions, this court has indicated timeline for adjudication of such type of matters where there is an inbuilt urgency, keeping in view the very nature of a relief sought. It seems that those orders passed by this court have not been able to bring the desired sensitivity as a result of which, due to which, the High Courts have apparently not evolved any robust mechanism for time-bound adjudication of the bail matters. Next paragraph. We are conscious of the fact that listing and prioritization of the matters for the purpose of listing is the exclusive prerogative of the Chief Justice of the High Courts, they being master of their respective rosters. So, however, if the people are languishing in jail, semicolon, their bail applications are not being even heard, and they are completely in and there is a complete uncertainty as to when will they be able to know the fate of their applications, comma, it seems that this court is under a bounden duty to lay down certain mandatory guidelines. However, before we do so, we direct the Registrar Generals of all the High Courts to send complete details of the anticipatory and regular bail applications pending in the respective High Courts, along with the date of filing, date of decision, or the next date of hearing. All the bail applications, such details shall be furnished, for the time being, in respect of all the bail applications which came to be filed on or after 1st January 25, filed on or after 1st January 2025. So, bail applications filed prior to 1st January 2025 are also pending. यहाँ पे है ना anticipatory bail application, then ऊपर स्टॉक करना applications for suspension of sentence. Three category. However, if such applications filed prior to 1st January 2025 are also pending, details thereof shall also be furnished. Next paragraph. Adverting to the case in hand, we find that the bail application filed by the petitioner is coming for hearing on 20th February 2026. We request the Honorable Judge to decide the same on merits, either on the date fixed or prior thereto, if an application, or prior thereto, provided that the petitioner seeks preponement of date. Next paragraph. Within 4 weeks, post the matter for further consideration on so and so day. उसमें लिखना, all the state governments are directed to fully cooperate with the High Courts for early and time-bound adjudication of the bail applications, prayer for suspension of sentence. The High Court shall sentence of the states should be ready with the relevant information as and when the bail application is listed for hearing, provided that a copy thereof has been handed over to, has been submitted in the Office of Advocate General and or the public prosecutor at least 3 days in advance. at least 3 days in advance. In such like matters, the investigating officers or the authorized officer can be permitted to appear online also. Next paragraph. The Registrar General of the High Courts are further directed to circulate this order amongst the honorable judges of their High Courts of our fervent appeal to them for expeditious disposal of the pending bail application. Next paragraph. The Honorable Chief Justices are also requested to revisit their roster stock listing arrangements, and wherever they find that there is a mismatch between the total pendency and the bench allocated for deciding such matters, they may consider the desirability of listing the bail matters before. They may expand the roster for listing of the bail matters. Post the matter on so and so date.
May I make one more submission, my lord? My lord, in cases of suspension of sentence, sometime what is happening that custody is more than 7, 8 or 10 years. Suspension of sentence bail application either pending or disposed of by listing the appeal. But appeals are also not being heard. And 7 years custody, 10 years custody after conviction of total, my lord may also call the record. The appeals in which custody is almost.
Say, Dr. Pankaj, that there are the system that has its own difficulty. If you start taking your only criminal appeal, the matrimonial appeal, the matrimonial cases, the other admission matters, academic matters, those get delayed. So some balancing has to be done.
There is no doubt that that is heavy roster, but 10 years custody is something.
No, undoubtedly we strongly disapprove rather if there is custody of more than 10 years, even normally in a case of life sentence, barring a few cases where death sentence is there or the crime is so heinous that life imprisonment means that he has to spend 40 years or so. In such cases, there is no question of granting bail. But then you pass an order, dismiss it, matter ends. Somebody with if they have a right to go in appeal, let them come. But keeping pending is what is bothering us. You pass an order, that is prerogative of the judge. Whatever order they want, they let them pass. Let us see.
Items 36, 37 are those Bengal SRs. In the sequence, it was supposed to come after 16. So, is that being taken up?
We'll take up to.
Because sequence was issued this morning. It said it's after item 16. Items 36 and 37.
After this,
fresh matters.
1 or 2 fresh matters are left.
Yes.
After that,
these are fresh. 36, 37 are fresh matters. Bengal SIR.
Those have been taken with us.
I'm grateful.
Just a minute, only 2 matters are left.
Very well.
I'm grateful.
Please.
Yes, item 40.
Yes, my lord, I appear for the petition. One.
You can argue from there now.
Only difficulty is, my lords, the elections are slated to, my lords, on Friday. My lords, my objection was dismissed only on 22nd. Also on 23rd, immediately I have moved the High Court. Immediately before the High Court, I have moved, my lords, the very next day.
They want to oust your opponent at the stage of nomination itself.
No,
You don't want to face in the election.
No, Malus, the only difficulty is that Malus, I have moved the High Court immediately on the next day. Malus, no hearing has been given.
If you win the election, then he is out by itself.
That is it. Malus.
Then
May I only make one request, Malus?
23rd.
options open.
Yeah.
But
Malus,
not
I'll
legal
withdraw,
options.
Malus, I'll withdraw this petition. Malus, only request is that Malus, this objection I may be allowed to raise at an appropriate stage. Because Malus, the difficulty I'll face otherwise is that the order of the returning officer which is against me.
Learned counsel for the petitioner seeks and permit to withdraw this petition with the liberty to raise all the, to raise all the contention at an appropriate stage. Order to court.
Very. I am highly.
Item 41.
Lordship, almost more than 90% encroachment has been removed from the government and forest land, Lordship. This fact is already acknowledged by the respondent number 2 to 5, Lordship. May I read, Lordship, annexure P5, Lordship? Page number 36, Lordship.
But why not remaining 10%?
Actually, Lordship, but there is a one BAME, Lordship.
My lords, I am appearing for R1, my lords, for Miss Chandel, my lords. My lords, my only two submissions, my lords. The first is, my lords, in the month of May.
If that pillar of the house,
My lords,
beam,
my lords,
normally they don't construct pillar in Himachal,
my lords,
but that beam or whatever support to the roof,
my lords,
that is coming in the government land.
my lords.
And if that is removed, the entire house will fall down.
My lords, they were new while they were constructing, my lords.
Like they knew.
Who is he, Lordship?
They were new the consequences of my lords. Still they constructed, my lords.
Who is he, Lordship? In which capacity is he appearing?
My lords, again, in the month of January, my lords, the petitioner again encroached the government land, my lords.
That we will.
They are using as a warehouse. They have kept their the materials, my lords. They are
Issue notice, returnable and so on. So that you appear for whom?
my lords are R1, my lords. Miss Chandel, my lords, R1,
R1.
my lords,
Or you are the complainant.
my lords.
Petitioner.
Original petitioner, my lords.
Original.
Original petitioner.
Then say so and so accept notice on behalf of Ishwan Barban. Counter affidavit can be filed within 4 weeks. Then say meanwhile, the parties are directed to maintain status quo at the site. That means that neither the house of the petitioner shall be demolished, nor the petitioner shall be permitted to raise any fresh construction. So if the petitioners indulge in raising fresh constructions, Respond Barban and the authority shall be at liberty to bring it to the notice of this court. And in that case, the petitioner will be liable to face the consequences.
My lords, meanwhile, they kindly directed to remove the
other response
to clean the, my lords, the path, to clean the path, my lords. They have
No path.
as per my instruction, my lord, they have kept their
There is no path.
materials to construct the buildings. my lord.
You take out the photographs, you will file counter affidavit and you place on the court the complete site plan, photographs and so that how the passage has been improved. Then we'll see what is to be done.
Well, obliged.
Deeply obliged, Lordship.
West Bengal Board of Trustees.
That's the way of it.
21.
36 and 37 are fresh matters. 21 is after notice.
Judge, may I just, I've prepared a note. I'm appearing for the petitioner in 37 and also in 21.2. So I just have a note because we need some urgent orders here. So would your lordship please just take this up along with, I'll request the court master to hand in IA 26838 of 2026. You got a copy of the note?
21 is on the board. That's also that's also ECI 21, which is the one now. The 21.
One, you are appearing in item 37.
I'm appearing in 37, but I'm pressing just now because this is a matter.
37 is by Madam Mamata Banerjee.
Yes. And
there is another matter, 36 is by Mr. Joy.
I'm in 36.
You are.
I'm in 36.
Yeah.
32 petitions.
Because it's connected to 21 and I'm requesting the court master to hand over its 21.2 IA 26838 of 2026. So, because the cross references in my note are to those particular documents. So I'll just request that. And I'll place this quite rapidly along with the writ petition. And there's an earlier IA also, 1884. Would your lordship have the note?
Note. All right. Yes.
Now, my lords, with your permission, may I just place, my lords, since
Go behind it.
Pancholi
Don't
was
push
not
me up.
there on in the bench on 19 January 26, may I just place this court's order of 19 January 2026?
19 January, is it the same order when Mr. Sibal wanted us to issue some direction?
Your
And we
lordship
put
have
those
already
directions?
passed direction, so this is just in furtherance of that. Your lordships have that.
Maybe that order of.
It's at page 30 of the IA.
Page?
30.
Not confused.
That's it.
IA 26838. Your lordship has that?
Yes, yes.
Yes. Justice Pancholi, I'll just go through this so that we'll get the thread.
The order starts from page 31.
That's right. Para 2. It appears that approximately 1.40 crore individuals have been issued notices for the purpose of document verification. These notices are broadly categorized into three parts, mapped. That is the category of voters who are linked with the 2002 SIR, unmapped. That is the category of voters who are not linked with the 2002 SIR. And three, the third category involves logical discrepancy, accounting for approximately 1.36 crore voters. The documents brought on record by the parties indicate that within the category of logical discrepancies include inter alia, a mismatch of the father's name, a mismatch of the parents' ages, a difference in the parents' ages of more than 50 years, a difference in the grandparents' ages of less than 40 years, and those having more than 6 progeny. With a view to enabling the person who are, as of now, included in the category of logical discrepancies, we deem it appropriate to issue the following directions. The names of the persons figuring in the logical discrepancies may be displayed at the Gram Panchayat Bhavans, public places in every taluk and block office and every taluk subdivision, as well as the ward offices in the cities and the urban areas. Persons likely to be affected are permitted to submit their documents, objections, through their authorized representative. Such an authorized representative can even be a booth level agent. There shall be an authority letter in favor of such representative, whether signed or thumb marked. Documents and objections may be permitted to be submitted at the Panchayat Bhavans of block or block offices. The Election Commission of India shall issue instructions for providing an additional 10 days time for the date of displaying the list in a Panchayat Bhavans block office to all persons who have not yet submitted their claims, documents or objections to do so within the extended period. The state government shall provide adequate manpower to the Election Commission of India and the State Election Commission for deployment of Panchayat Bhavans block offices to handle documents, objections, and hear persons likely to be affected. In this regard, we direct each district collector to meticulously follow the instructions issued by the Election Commission, state government for deploying adequate staff and forces for ensuring smooth functioning. Director General of Police, West Bengal, Superintendent of Police in the district, and the collector are instructed to ensure that there is no law and order problem. All affected persons may, in addition to being given an opportunity to submit documents, materials or objections, also be heard at the time of either in person or through the authorized representative accompanying them for the purpose of making an appropriate decision. The official will receive the documents or record a hearing to the affected person, may also certify the receipt of documents, and that important direction in para 10, Madhyamik class 10 admit card, which discloses the date of birth of the candidate, may be submitted apart from the Madhyamik pass certificate during the...
Direction number 10 was issued.
Yes.
Because we, at least personally, I had the advantage of my two brothers from West Bengal being with me.
Yes.
And they were able to point out that this is the way in certificates are issued in West Bengal.
That's right.
Therefore, because of their having been pointed out, so that's why we included in 10.
Now, Manoj, may I request you to take up the note so that we just very quickly and rapidly go through that. So please see, this is a brief note on behalf of the petitioner. Your Lordship has it. That's the heading, right on the cover page. Sorry. Of the note, which is a snapshot. Now, the number of days left for the final publication.
Separate note you are talking.
Yes, well, just save time. This is the full, the submission which we're going to make and the request. Number of days left for final publication of electoral roll is 11 days. So that's up till 14 February 2026. Number of days left to complete the hearings is now just 4 days left on 7th February 2026. Number of voters categorized on a draft roll as unmapped is 32 lakh. Number of voters categorized as logical discrepancy post-draft poll publication is 1.36 crores, which is 20% of the electorate of West Bengal. Number of hearings held since, now this is just to give you an idea, since 16th December 2025, which is 41 days, so far they've held 88 lakh hearings in respect of 88 lakh voters, which is at the rate of 1.8 lakh per day. The number of hearings pending is approximately 63 lakhs. And this will mean that if we are to, which an endeavor would have to be made, if we have just 4 days left, they will the speed of verification will have to go up to 15.5 lakhs per day because there are just 4 days which are left for 63 lakh. Documents pending for verification at the DEO level in 11 days from 88 lakhs hearing completed. So we have indicated that number. Documents verified by DEOs in 41 days was 52 lakhs. Number of, now just note this because there's a set of submissions here. Number of micro observers deputed without any statutory basis. This is 8,300. I'll make a short submission on this micro observers because they don't seem to be contemplated under the constitution at all. Even under their manual of operations, it's a very, very limited role which they have on election day, but not the activities which have been deployed right now, which has been given to them at this stage. Number of approved documents rejected after hearing stage commenced. Now, this is one of our grievances. The Panchayat residence certificates, the family registers, the domicile certificates, Aadhaar card, OBC certificates, and land allotment certificates. None of these are by themselves being accepted. And despite orders of the court, and then, my lords, we have mentioned because people are waiting in 4 and 5 hour queues over there. Now, please go over to page 2, para 5. We formulated the specific point here. Now, the first suggestion is non-statutory category of logical discrepancies used to issue notices to 1.36 crore otherwise eligible electors. Now, this is our request. Direct the ECI to upload the reasons of each elector flagged as logical discrepancy cases online on the ECI website. May I request you to directly go to page, we explained this more fully, but just go to page appendix 1 at page 8 of the same note. Now, I'm just giving you an example.
That should be appendix 2.
My mistake. Please go to appendix 2, appendix 2. Page 11.
Page 11?
Yes. Now, pursuant to your lordship's directions, this is what is being put up. But as you will see, so the name of the elector is there, age, gender, and then the category notice just says DM, which is discrepancy in mapping. But the person doesn't really know when this is put up on those, the reasons are not indicated over here. So what is the reason for this particular discrepancy in mapping?
Mr. Diwan,
yes.
We were informed that this is on the website, but when the notice is given to the person
Yes, you're right.
the particular
Yes, we've given you that example. You're right, but there is a lag as far as those notices are concerned. So we are suggesting some short reason should be indicated on this as well, because it will help the process. People will know why are they on that particular list. What's the reason for the list? Yes.
To the extent that person must know the reason.
Yes.
Is absolutely justified. There is no difficulty. The only question is that what is the mode of communicating that reason? What we have been told on the date, but because on 19th when we were passing this order, we were also, because we thought that we are issuing very comprehensive direction so that there is every procedural part is smooth sailing.
Yes.
Now we were told on that day that this list is not the only communication. Communication is individual notices to the person included in the list of discrepancies.
Yes.
And that notice then define That notice.
Sir, we've given you a sample in the note. You're right. You're absolutely right. For example, page 9 and 10.
All notices are containing the reasons. The lordships have also permitted them to take a representative lot of whether BLA or otherwise as they want.
But this will certainly help if it is up there on the note and a short reason is indicated. The notice may carry, given the numbers which we are dealing with, by the time somebody receives it, reads it, etc. So this is my first suggestion.
So for example, page 9 as you are referring to.
Yes, page 9. We've indicated over there.
Now, it said due to the mismatch between the name of your father as well as the current electoral rolls and as given in the electoral roll prepared during the previous SIR, as per the linkage shown in your enumeration form, you seem to be incorrectly linked with the electoral rolls. I think this is a reason, a well-explained reason.
Yeah. So now I want to just take this. I'm obliged to your lordships. Now please go back to my note. Just go to page 2. I'm going to now build on this point.
Page 2.
Yes. So on page 2 of the note, 5A1, I have made the point, then your lordships will see upload reasons is what we suggest. Now, number 2, in 5A2, direct the ECI to withdraw all notices under the category which pertain only to name mismatch. Now, look at this. Yeah.
Page 5. Page 5. 5.
I have nothing to say.
5A.
Yes.
This A, then clause 2.
Yes.
Where you are
the name mismatch.
Are you referring to the cases? Say, for example, just on illustrative basis.
Yes.
So, for example, one person writes Datta.
Yes.
Somebody may may spell it as D-U-T-T-A. The other may spell it D-A-T-T-A.
Absolutely.
That is one part.
Yes.
Similarly, Banerjee, Bandyopadhyay. Similarly, in Sarma, somebody may write SH, somebody many of them write SARMA.
So your lordships have exactly anticipated what we have set out in paragraph 7A. In fact, we've given Datta, Ganguly, Roy and Ray as examples. But we've given actual examples of what is being faced at page 8.
But now, according to you, you see.
Look at, sorry. One is
tell them to withdraw the notice will be is something very impractical thing because notices have been issued.
No, I'm suggesting. My suggestion is that our estimate, it's an estimation that in the logical discrepancy cases, please go to paragraph 7A on page 4. Just go to 7A of the note, page 4. A majority of the logical discrepancy cases, more than 50%, which is around 70 lakhs, are cases of minor name mismatches and spelling variations. And we've given the very examples which your lordship. Page 4 of the note. 7 subsection para A. A majority of the logical discrepancy cases, more than 50%, are cases of minor name mismatches and or spelling variations, and your lordships knows. Now we've given you an actually of actual electors. Please go to page 8. This just builds on the point which your lordship made. Please go to appendix 1, which is page 8 of the note.
Page
8. Now, your lordship has it. So now Mr. Chirag Tibrewal, his discrepancy was father's name mismatch. My father's name was Kumar in the middle. Your lordship has it. Last column. My father's name has Kumar as the middle name in the 2025 SIR, which was not there in the 2002 SIR. I have been served a notice and called for a hearing on 27th January. Look at serial number 5.
Three, just see 3.
All right, 3. Well, let's please see, this is Ajimuddin Khan. Now see what has happened in his case. Father's name is shown as KHA, Alauddin Khan, in the Bengali, whereas it should be Alauddin Khan. Because you see, from the one from Bengali into English and vice versa, you can lose this. Yes. This may be software.
Illustration number 3 may be slightly difficult. Because here you are saying Azimuddin. No, Azimuddin is...
No, it's Alauddin.
Father's name,
father's name.
So the spelling mistake is, or spelling difference is in the name Alauddin Khan.
No, that's his father's name. Please just see.
The Chandramatra there.
Yeah.
The form in Bengali.
Okay. Khan has become new, but not
Yes.
But
And this is not in other states.
Okay.
This is different.
The 2002 electoral roll was in Bengali. So when they translated it for this purpose.
Out can be. All right. What is your solution? Because then we are also thinking.
No, because there are 2 ways of looking at it. One is, look, this name discrepancy, my lords, which is the bulk of it, is cramping even the available time, which is just a few days. So these name discrepancies, my lords, should not be within this logical discrepancy to knock out people from the electoral roll, because look at the inconvenience. Look at one of those notices.
Your solution, Mr. Dwivedi, have you think about it?
Actually, more than a crore hearing have already taken place. Few more which are left.
No. What about this kind of discrepancies which are not even a spelling mistake, which are only on account of how you speak in the local dialect? This happens pan-India. It happens in Haryana also, it happens in Punjab also, it happens in West Bengal, it will happen in Tamil Nadu also.
Yes. So we don't have instructions. The same chart given to us just now, it's not there in the IA, etc. But ordinarily, what my instruction...
Mr. Diwan, let's find out...
name mismatch not being purged.
I don't want to interrupt.
Please don't purge people.
Mr. Sibbal, you are unwell today, you better take rest.
I am going to, but I just want to interrupt. Your lordships will remember, Mr. Dwivedi made a solemn statement, then where is this kind of discrepancy, we're not going to bother about it. Your lordships will remember that. He said, if it's a question of spelling this, I'm not going to, this is not something that will be.
Bengali, if you were in Bengal, Mr. Dwivedi, you will be pronounced as Dwivedi. B will become B.
And you will also be ousted.
Yes, then you will have been spurged.
Language doesn't have a war.
Gujarat will become...
Bengali language doesn't have a war. Or yeah.
Instead of my brother being addressed as Vipul, they will address as Vipul.
On this aspect, may I just... Sorry.
But my name, there will be no mistake, because it's a basically Bengali name.
Sir, it may be, sir. Sorry, sir.
With your
Because you...
permission, could we just have an insight over here from... Yes, please.
5 minutes.
If you allow me.
So, go ahead.
So my understanding was that mere spelling mistakes notices are not being issued.
Are being sent.
But now that this chart is being issued, is shown to your lordship just now, I need to get an instruction. Your lordship may have it tomorrow or day after, whenever I can.
The executive head of the state is also very much present. If the state government provides a team of officials who are well conversant in Bangla and who are well conversant with the local dialect, and they scrutinize these, just scan through this and tell the commission that this is here only a local dialect mistake.
Yes.
and not any identity mistake.
Yes.
That will help them.
No, it will help them, but it's apparent.
Oh, Johnny.
Actually,
Apparent in some of the cases on illustrative basis it may be, but it will become humanly impossible for you or for us to go through and to.
Lordship,
May I explain you, sir?
Give me time till tomorrow day after, Lords, then I can get back.
May I explain you, sir?
Because in my view.
Because I belongs to that state. I am a.
Can there be any doubt, Madam?
No, sir. No, sir. I am very grateful, sir, because of your kindness, my humble regards to my Honorable Chief Justice, Mr. Bagchi and Mr. Panchali also. Panchali ji also. Thank you very much. And my humble regards to Mr. Dwivedi and others, my opponent lawyers also. Sir, the problem is, always our lawyers fight for the case and they're fighting from the beginning. We are also. But sir, when everything is finished, when we are not getting justice, when justice is crying behind the door, I quote Rabindranath Tagore, then we thought that we are not getting justice anywhere. So many times I have written 6 letters to Election Commission, including all the details. But no reply, sir. I'm a bonded labor, sir. Maybe I prefer that. I'm a very less important person. I prefer that. Sir, I'm from a common family, but I'm not fighting for my party.
Madam Mamata, sorry for interruption. The state of West Bengal, in its own right, has filed a petition, right? Today, of course, you are also coming in your individual capacity, but state of West Bengal, in its own right, there is nothing wrong in that. State of West Bengal has also filed a petition.
State of West Bengal has not.
One of the best counsels in the Supreme Court, fortunately, are there to not only are to represent the case of the state. Mr. Sibbal appeared on that day. Today also, incidentally, Mr. Diwan is there. Then in the other matter, Mr. Gopal is there. The best of the team, the legal team in the Supreme Court is there to assist us in the matter. Mr. Sibbal, though slightly elemental.
Sir, if you allow me 5 minutes only.
Now he is there.
Only 5 minutes only.
We will give you, not 5, we will give you 15 minutes. We are only pointing out that on 19th January, when the matter came before us, Mr. Sibbal very eloquently he explained the procedural difficulties which the state was experiencing and where the state had some genuine apprehension for exclusion of the bona fide citizens of the India, citizens of West Bengal, the residents of West Bengal who are citizens of India. So therefore, those directions, the direction which Mr. Diwan just read out were issued. Today, in your petition, some additional issues are being flagged. Absolutely right. Issues are being flagged. Every problem has a solution. So we must look toward the solution in order to ensure that no innocent citizen is left out. This SIR is based upon only on 3 grounds. Dead persons excluded, no difficulty, neither you will want, nor anybody will plead for the dead persons. Similarly, the persons who are disqualified to remain for any reason, somebody is convicted, whatever may be any ground in the law, you will not plead their case. Similarly, those migrants, the word is migrants, migrants is also one of the ground. Those who have left West Bengal, even you will not plead there. But the genuine persons must remain there. Now, among the genuine persons, one of the ground, as Mr. Diwan has today flagged, and we are thankful to you also that in your petition now this issue has been raised, that because of the local dialect or because the manner in which the Bangla people will proudly pronounce a name or because of that, and this all because nowadays AI assisted computerization, that you are speaking Datta and they are recording something else. If this kind of things are happening, we will find out a solution. They will have to find out. They can't. They will not like to run away from that responsibility. That by virtue of this kind of mistake, the genuine and bona fide person must not be excluded.
Sir, what happens now?
Only one.
Sir, what happens now?
Permitted before they could open millets. insofar as the Election Commission of India is concerned, I represent. In that matter, so far we have not been served with any pleadings. We are clueless what their grievance is. If it's been there, if it's served on us, a week's time given, we'll get all instructions, we'll place it before your lordships and look forward to any genuine difficulty to be redressed.
Week's time will be too late.
So be it, Millets, let it be on Monday.
Week's time, let them.
Let it be on Monday.
Sir,
Because Millets were clueless what the grievance is.
sir, this is not,
I understand.
Item
Sir,
21
please
is
allow me, sir.
the reply in
It has not
21.
been served.
You are right in saying that you have not been even given copy because
No.
the matter is coming first time for hearing.
Indeed.
The only thing is that since all this entire procedure has a timeline, at that timeline, we had extended on 19 January for another 10 days.
True, Millets.
But that 10 days time is also now, because they rightly pointed out by Mr. Diwan that out of that extended period, only 10 days are left. 4 days are left. After those 4 days, only 11 days are left. So this being a timeline, we can't grant you the luxury of 1 week notice or 2
Millets, on Monday, so that, sir, we'll come to know what the grievance is and we'll suggest or place before your lordships the remedial
Sir,
measures.
please allow me to finish my point, please.
In principle,
Yes.
if it is happening that Roy, Datto, Ganguly, Upadhyay, anyone like this, by virtue of the local dialect, if the name is being spelled out slightly different than what the accurate words might be, somebody can say.
Precisely.
In a given case, we do not know how Tagore is also defined. Maybe somebody put the E in the last, somebody may not be putting E. But that does not mean Tagore is not Tagore.
Millets.
So you also have to
Millets.
come out with a
What they cannot
technical
afford
way
to
out.
forget
So
is-
is the state can suggest us, so we will.
Millets, even the field staff are local, they pretty well know all
Respected
these
Chief Justice, sir,
Not that
I am
something imposed.
giving you the example. I can show you some photographs. If you allow me, only I want to submit, sir, I want to lay, because it is not my photograph. All the Bengali leading newspapers, it is reported. You'll be surprised to know the, sir, only, sir, my submission, sir. Sir, their SIR process is only for deletion, not for inclusion. Mismatch, not only the title, sir. Mismatch, mismap, unplanned. Now suppose a daughter after marriage, she go to the in-laws house. Now why she's changed her title? Why she's using the husband's name, husband's title? That is also mismatch. Yes, sir, they have done it, sir.
That's why we are.
Now,
That's
sir,
why we
only I just want to say. Number two, sir, there are some daughters who married and shifted the in-laws house. Their name also just unilaterally deleted. It is just because they shifted their houses. Sir, you will appreciate sometimes some people work some office, they go to they transferred other offices, they work somewhere. Sometimes the poor people, they purchase the flats, they shifted their addresses, but they are the genuine people are staying there. But because of the name of logical discrepancy, now they change the name. No, instead of logical discrepancy, when you gave order, sir, they violated, and they say it is the discrepancy mapping. Sir, can they even violate your order? Number two, sir, we are grateful. Bengal people are so happy that this court gave order that Aadhaar card will be one of the proof documents. But they said no, only with Aadhaar card. Sir, in other state, sir, the domicile certificate is allowed. Sir, the family registered card is allowed. Sir, the government housing card is allowed. The health card is allowed. The bank books means whatever caste certificate is allowed. Only they targeted Bengal on the eve of election. Sir, 4 state, opposition state are going for on the eve of election. But why? After 24 years, what was the hurry to do it? What it takes 2 years, only within 3 months, even when the festival season is there, when the harvesting season is there, when people are not in a mood to be in the city, they were in the outside, but they are traveling, and that time they issued the notices and all this. Sir, more than 100 people died, sir. Can you imagine? Sir, BLOs died and they have written the letter that CEO is responsible for my committing suicide. So many BLOs are murdered, they died. And also more than 150 people died and so many are hospitalized. Sir, because of the harassment of the people, because of Bengal is targeted, sir. Sir, you tell me why not Assam? Sir, why not Assam?
The state government, we cried foul, saying that
why not Assam?
Cooperation. They say
why not Northeastern?
Madam has come all the way to speak something.
Indeed, my lord. But the only thing is that, my lord, if it's off the record, we need to.
Madam Mamata, let me clarify 2-3 things to you.
No, this
About
is
the Aadhaar card, this matter about SIR's validity issue. SIR's validity issue is being argued before us from last more than 2 months. In the main judgment, which was the first case, we have reserved the judgment. Therefore, we are not in a position to comment with regard to the credibility, credential, or admissibility, and to what extent about the Aadhaar card. That issue has been argued before us. We have reserved the judgment. But you also will appreciate card has also its own limitations when you will read that statute under which it is issued. At the same time, with reference to its insertion in the RP Act, what will be its value? We are yet to determine that part. You have one part. Second, you have pointed out this issue of the discrepancies part. In this case, one way out can be that you give a team of officers, the Election Commission can take them on deputation in the sense that those can also be part of the Election Commission team, verify that here it is a spelling mistake or it is only because of the local dialect that this mistake is occurring. Those must be rectified. That has to be rectified. So let us see what response they will give. We will grant them 1 day time. Tomorrow or day after.
No, sir. What happens, sir, ultimately, in practical, ERO has no power now. They have superseded all the power from DO, ERO, BLRO. Only they have appointed 8,300 micro observer and the roll observer from the BJP ruled state, so that DO cannot clear the name. It is all micro observer can delete all the names sitting inside the Election Commission office through AI. Sir, earlier 58 lakhs are being deleted. Even they were not allowed to file Form 6. Sir, earlier first phase, 58 lakhs deleted. There are so many people are alive and now they are being declared that they died, their death. Sir, the anti-women, so many women.
Madam Mamata, if need arises, we will mandate it, we will direct. Every document will have to be signed by the BLO, who are the authorized officers and who are the authorized notified officers.
Kindly see the directions on the website, Millers, so far as the so-called micro observer.
Micro observer is the final authority. Election Commission, WhatsApp Commission. WhatsApp Commission is saying it is only the micro observer. Only they are deleting all the names.
They could certificate on record.
They are all Government of India officials.
My lord,
they are.
Lord, in one of the matters, government is a party. Lord,
But the problem is that they are not allowing the people.
let the matter.
They are not allowing the state officials.
Possibly for most of the submission.
They are not allowing the domicile certificate.
Day after.
They are not allowing the government certificate.
Let that be a direction, Millers. We should be served the copies.
May I just highlight?
I have something.
Yeah, I just want to highlight 2 points. If your lordship would just take up, I want to save time, so just go to my note for a moment. Just go back.
Lord, I want to intervene for 1 minute, Lord, if lordship permits, Lord. We have written several letters to the state government to give us Group B, Lord, the class 2 officers of the rank of SDM or equivalent, so that, my Lord, EROs can be appointed. That's the standard pattern, my Lord, that they should be class 2 officers because they decide vital rights, papers and all that.
No, that has
now they have given, my Lord, only about 80 officers of that rank. Rest, all of them were given who were clerks and below, who are working under the pressure of the state government. Therefore, we had to appoint, my Lord, micro observers who can assist, my Lord, in case, my Lord, they are in the confusion. So the fault lies with them in not giving us class 2 officers for performing the job of AERO and ERO. So that's the reason why this is happening. And these micro observers are validly appointed under Section 13C, read with 3.
No, there is no statutory rules.
my learned friends are not right, Lord, that they are not, we are not entitled to appoint them. If this is the state of affairs, which is not contemplated by the rules and the state is not cooperating, then there's no alternative except to appoint the observers who can assist. Class 3 officers from Anganwadi and so on, they are being given to us. So that's
And
the
this is the
reason why
communication.
assistant.
There is only one.
But they are not assisting.
There is
They are
one,
taking
one,
They are
lordships
taking
have
decisions, not
one
assisting.
side of the story. May be true, may not be true, I'll not go into it. So there is one more petition where the Election Commission of India has filed an affidavit. So that also may be taken on record. It's not listed on board. It was mentioned by Mr. Giri. Lord, I am appearing in that matter and I have read the affidavit. Lord, that also will have some bearing, my Lord, in ultimately what your Lordship passes the order.
And we have highlighted all the difficulties we have been facing, Millets.
My lord, my lord, my lord.
My Lord, it is pointed out the
Yeah,
hostility.
just
which
have
is
2 minutes. I just
On a role of
I just want to
observers,
highlight.
a victim, that's all, my Lord. I am saying let us confine.
Ultimately, we
No,
will
no.
ask them to at least 2 days time we'll have to give
Yes,
them
yes.
to seek their response.
Sir, matter is not correct, sir.
Survey copy, Millets.
But fair enough.
Wait, I'm-
What I'm highlighting is
There
just
is no
2 things so
problem.
that your Lordship sees them.
Let me say this, no, there's no problem of time, my
The
Lord.
the first,
Have some buffers if there is
Arey bhai, eta
more than 1 crore already heard. And if somebody is not heard, your Lordships are there and we are, our power is
We
there.
have been extending time. We have been extending time. We have been.
My lords have passed a slew of directions.
My lordship,
Every
my
aspect-
lordship with my humble regards. May I tell you, sir,
Whatever they have pointed out.
my
and
opponent lawyers raised.
Said that.
Sir, that is not correct.
Madam
That is not correct, sir.
Madam Mamata, we have no doubt about the ability of Mr. Diwan. He is one of the best senior counsel you have chosen.
Yes,
Let him
with his
assist us
permission.
on your behalf.
With his permission, sir. Only one thing, sir.
Your point we have well taken.
Sir, it depends on some district,
Kindly
some states, sir. We are suppose 44 district. We have 23 district. Now SDM is depends on the district wise. Now whatever we have the strength, we have included all.
Alright.
We are cooperating to them
Are you
all.
prepared- are you
Micro,
prepared to provide class 2 group?
yes, we have given, sir. Whatever they ask,
Alright.
we have given. But they are telling
All right. Please.
what I don't believe.
I think we will be able to find out a practical solution.
Very well.
On Monday, when we take up this matter, we are granting them 2 days time to have instructions based upon all the notes and information which you have gathered.
Very well.
And you also on Monday, please give us the list of the Group B officers which you are in a position to spare
Yes.
and to provide to them for their
Furnish it in
assistance.
advance.
So that
And your Lordships may list that matter also because
Yes.
there is direct bearing on that.
ICT.
There is an atmosphere of hostility. Election Commission says.
And it contains all our communications
Yes,
to the
but with
government.
written
Trying for
communication
help.
issued contemporaneous.
issue notice.
Lords, I have one apprehension, that's all I have. I don't want Mr. Dwivedi coming on Monday and saying, now we have finished 1.2 crore hearings as a figment of his
It's all right.
numbers.
We are entitled to our defense.
That's what we're saying.
That's an ongoing exercise that will continue.
Sir, only my last submission, sir. Sir, what about they have only first phase 58 lakhs deleted. They didn't have any scope to appeal even Form 6. Number 2, the second phase, 1 crore 30 lakhs. Only my request would be, whatever the system is maintaining the other state, they are only targeting Bengal. Only for Bengal, they appointed these micro observers.
Not the forum, Millets.
Yes, for to bulldoze the West Bengal people. Sir, my humble submission will be, sir, the logical discrepancy case not to be deleted. And there should be, as it is, it should be cleared by the DO and the ERO, not with the micro observer, not with the role observers.
Millets, they as well see your lordship's directions on the last occasion.
Give us the list of the officers whom you can spare.
Yes.
Whom you can spare.
Yes.
Probably, once the officers are made available,
Yes.
then micro observer will not be
May
required.
not be necessary. Absolutely.
Millets will
Yes.
Yes, absolutely.
Can do it.
whatever
So Monday itself, we are taking up the matter on Monday. Meanwhile, they will also get instructions and you also give us that list.
Very well.
Mr. Diwan, please ask your junior to give
Yes.
complete set of paper book.
Of course.
In both matters, we'll.
Both matters. And in Mr. Gopal's matter,
To item
he
37.
is very learned in
Sir, with my humble regards, I convey my great regards
personal fame.
and I will just tell, save democracy.
1 minute, madam.
Joy
Save
Goswami,
democracy.
he is a renowned author, Jnanpith Puraskar awardee. There might be some mistake. Please, you tell your officers also to be a little bit sensitive.
We'll examine, my lord.
Don't issue notice to persons like.
We have never been divorced from common sense. We are addressing them.
Some
If they
extra
want
time
to
is
make
required to be spent
sensationalism,
on
that's
No, just one last thing I want to flag. When we argued the merits in Bihar, your lordships noticed this logical inconsistency, etc., were not issues there. The problem is every time a new state comes up, there will be a new issue which has absolutely no constitutional.
Every day changing the decision.
state may have its
now
own
after
problems.
this, it will
As
come
they have
up.
been creating.
New issue. Gopal,
Yes.
every state will have some new issue.
Exactly.
It is bound to be also.
But it has to have a legal basis. Without a legal basis, they can't start examining something which is not from the
If
draft
the
code at
state
all.
government fights the constitutional
Issue
body,
notice.
what could be the legal
Issue
basis?
notice in both the matters. Issue notice, then assisting counsel wants to accept notice on behalf of the Election Commission of India, wants to accept notice on behalf of the Chief Electoral Officer West Bengal. Then say we have briefly heard Sir Shri Shyam Diwan and Gopal Subramanian, then senior counsel on behalf of the petitioners, and Sir Ms. Trivedi and Rakesh Trivedi and Mr. Naidu, and senior counsels representing the Election Commission of India. During the course of hearing, it is pointed out by learned solicitors of India that there is another petition hearing number so and so, and the issues raised therein or the affidavit filed by Election Commission of India will have some bearing on the merits of these cases. Consequently, that order petition is also ordered to be taken up along with these cases on Monday, due to date of the Monday. The parties shall have respective instructions on the date fixed.
Great.
We'll take up on Monday.
Monday. Grateful.
Thank you.
Sir, we are very grateful, sir.
Grateful, madam.
No, of course, sir. Of course, sir. Please protect the people's rights.
म्यूट कर दे।
Lordships had fixed item 22, the DGP matter at 2 p.m. Your Lordships, there was some urgency in Tamil Nadu because elections are there. Your Lordships had fixed 22, the DGP matter. In that, the Tamil Nadu DGP application, Your Lordships, has some urgency because in May the elections are coming and UPSC has sent the recommendation as directed by Your
Let's take
Lordships.
up that matter just now.
Very well.
Yes, yes, Mr. Jain, what is the position in this matter?
Lordship, on the last occasion, you had very kindly ordered that all the AORs should file supplementary information. So far, I've received about 150, total about 550 AORs information I've received. Another 600 odd are pending. We are pursuing with them, sir. Second, your Lordships had ordered that some interveners had petitioned this honorable court that they are not part of the subvention scheme. You had asked to examine. I'm in the process of.
To be detect kind of.
Yes, sir. I'm in the process of doing that. I'll solicit some more time from you, sir.
So that will take some time for you also to examine.
Yes, sir. So I prepared a brief report, but there's nothing substantive but for what I've mentioned.
And what about the investigating agency, Madam Ashwin?
My Lords, we have received 44 petitions, my Lords. We also have a status note, but there is nothing substantial in the last status report that your Lordships had already seen, my Lord. After that, we are scrutinizing the, my Lords, the documents that we have received. Once we scrutinize it, then we will put it in different categories for your Lordships to see.
Any information regarding this Rouse Avenue court where the charge sheets were filed?
Yes, my Lord. So this status report has that update, my Lords. The 3 RCs.
Oh, you are filing a status report?
Yes, my Lords. I'm carrying a status report. So, my Lords, there were 3 cases that we had completed our investigation. Cognizance has been taken in all 3, my Lords. The date your Lordships will find. This is 3 regular RCs. Cognizance taken is the last column, my Lords. 27 January, 3rd of February and 3rd of February. 25 RCs are under active investigation. And my Lords, we've also, para 3, if your Lordships will see, in the 28 regular cases, we have also my Lords, divided them into 2 portions. 22 cases are projects involving subvention schemes. And therefore, it involves the PC Act, my Lords. 6 cases are cases which do not involve subvention scheme. These 28 regular cases, my Lords, covers 39 total projects and 17 financial institutions. In last status report, this bifurcation was not given. Only I have given the bifurcation and updated status of cognizance.
The bifurcation mentioned in para 7?
Para 3, your Lordships will see. Bifurcation of...
That's right. 22 plus 6.
Please, my Lords. And our investigation is continuing in the rest of the 25 cases, my Lords. And the 44 cases that we have received from the Learned Amicus's office, we are scrutinizing that, my Lords.
Para 10, they are saying that from your office, a list have been received, but not the copies of the petition.
Yes, so my lord.
The consul have not supplied to your office.
Yes, but my lords, let it not be duplicate. The learned amicus is giving us everything. I think that is fine. 44 we have received from learned amicus. Because 20 of them were anyways common, we tallied, my lords. So we'll just let it be one source from the learned amicus.
My lord, one submission. One of the charge sheets relates to, my lord, one of the companies which has gone under CIRP. My lord, in view of the CIRP process, my lord, I become the successful resolution applicant. The law now requires, my lord, that that company which is now gone through the CIRP process will be bereft of, my lord, a prosecution under 32A.
There is a question of deleting.
No, the erstwhile promoters will be proceeded against.
We really don't give much credence to this so-called CIRP procedure and all this.
My lords, if I may submit, I'm for one of the impleaders and I pray for the stay of the check bouncing proceedings. He has a similar case and FIR has been registered pursuant to the orders by this honorable court against the builder, AVJ Developers. The CBI has registered an FIR. I am praying for stay of the proceedings of the check bouncing matter.
Those matters have been stayed.
My lords, it was before I became a party. I have filed impleadment and directions.
Saying continuation of the previous orders, including dated 22nd July 2025, 28th July 2020, 23rd September 2025, and 20th January 2026. Shri Rajiv Jain, Learned Amicus Curiae, has submitted a brief note number 5, 24th February 2026. It is pointed out that in terms of our previous order dated 20th January 2026, liberty was granted to the petitioners stroke IA applicants in the IA stroke interveners and all other stakeholders to furnish the requisite information to Learned Amicus Curiae with respect to the date of disbursement of loan, installments paid, the status of the project, etc. A format for furnishing such information was also incorporated in the order dated 20th January 26. Next paragraph. In response thereto, information have been received in 216 special petitions pertaining to 1,192 petitioners. However, only 534 of them have furnished information in the prescribed format. Next program. As regard to the liberty granted to the banks stroke financial institutions to submit their claim for deletion of their names or detagging on the premise that they are not they, they have not launched any subvention scheme. Comma. Only two banks stroke HFC have approached the land amicus two financial institutions, namely L&T Finance Limited and PNB Housing Finance Limited, have also sent mails for their deletion.
If I may, sir, learned counsels for some other housing finance companies or banks informed me today that they have submitted emails to me on this same subject. Somehow, perhaps in the barrage of emails that I received, I may have missed that. So Central Bank of India, ICICI, HDFC, they all said that they've also submitted an application to this effect. I've yet to verify, sir. Yes.
They also, State Bank of India.
Central Bank of India, HDFC, ICICI.
Have also submitted their claims. All these claims are yet to be verified by the Land Amicus Bureau. Though in the report he has opined that PNB Housing Finance Limited and L&T Housing Finance Limited apparently relate to subvention matters. Next paragraph. Since most of the petitioners, criminal, etc., have furnished information very recently, and over 658 petitioners have not come forward. In the interest of justice, we are inclined to grant one more opportunity to those who have yet not furnished the requisite information, to approach the Land Amicus Bureau and submit their respective claims within a period of 1 week. Next paragraph. Land Amicus may examine the claims received so far and may submit a report after collating the information from preferably within 2 weeks thereafter. 1 week after.
Lord, may I submit some? Lord, on this issue of, because some of the builders have approached the amicus and the banks that detag because it is not a subvention scheme in the strict sense that the builder did not launch a subvention scheme, but the scope is builder banker nexus. So if there is a upfront disbursal by the bank to the builder without linking it to stage-wise construction, then it's a clear case of nexus and without verifying whether the builder has clearances.
Nobody deleting them. They are only submitting claims. And the Land Amicus will examine it, then a report will come to us.
Because their objective is, once it is detagged, then it goes out of the purview of CBI.
It has been detagged.
Yes, exactly. Because if there is no tripartite agreement,
a status report within 2 weeks thereafter. We also request, number 3, now we also request bikers to submit a report to highlight in the report the categorical status with respect to the claims of the parties. Next paragraph. CBI has also filed its third interim status report in a sealed envelope which has been opened in court and the report produced. It is explained that in total 28 regular cases have been registered, out of which 22 cases pertains to builders projects involving home loans and subvention scheme. All these cases have been registered under the Prevention of Corruption Act also against unknown officials of financial institutions. Next point, the remaining 6 cases pertain to builders projects not involving the subvention scheme. Everything note?
Pertaining to builders projects not involving the subvention scheme.
Three charge sheets filed. It is further explained that out of aforesaid 6 non-PC Act, CBI has completed the investigation in 3 cases and charge sheets have been filed. Investigation in the remaining 25 regular cases is stated to be presently ongoing. It is further explained that at present 25 regular cases are under active investigation and 3 cases wherein charge sheets have been filed have been detagged. The details of these cases are given, is also given in para 7 of the interim report. The affidavit further explains that the list of 45 SLP stop petitions filed meanwhile have been received, but no soft copies of, but out of them, soft copies of 44 SLPs have not been received so far. It is however stated by Madam S.P. Bhatti, Additional Solicitor of India, that since the learned amicus is forwarding the soft copies to to the investigating agency along with his opinion, there is no need of overlapping directions for supply of the soft copies in the remaining cases. Also post after 3 weeks.
Yes.
My lord, my
ma'am.
IA for stay.
The above stated directions and directions to observation may be complied with.
My lord, if I may be.
Just a minute, just a minute. So in writ number so and so, it is stated that despite tendency of these matters, where most of the cases interim notice have been issued, a complaint filed under section 138 NIA Act by the bank.
Yes, by the bank, ICICI Bank.
Bank is being pursued against the applicant petitioner.
Ma'am,
Hmm?
I'm for the ICICI Bank. I am not sure which matter my friend is talking about. Because if the information be provided, we comply with the stay order. I apologize for interrupting. I'm saying I'm not aware of which matter my learned friend is talking about. If the information.
So, right, may not be aware. Notice has been issued.
My lords, on the last date, we were directed to submit to amicus. We have already done so, our IAs. Notice has yet, my lords, I have filed 2 IAs, one for impleadment, one for direction.
Issue notice, returnable so and so. Otherwise, will you accept notice?
Please, I'll accept the notice.
And so and so accept notice on behalf of the so and so respondents. And so meanwhile, posting the complaint in section 138 NIA shall remain state.
By
IA, notice has been issued, kindly stay the criminal proceedings.
There's one
Initiated by the bank.
19.142. Actually, it's a transfer petition of the petitions which are already pending before Karnataka High Court to this court. Now, the CBI and the amicus both are investigating the same project. But parallelly, we requested the Karnataka High Court not to proceed since your lordships are already cognizant of. But they are still proceeding. So we have filed an application, my lords, directing the Karnataka High Court not to proceed since CBI is already investigating. The amicus is also, my lords, looking after the whole project, my lords. The petitions have been filed here. Let not the Karnataka High Court do a parallel proceedings may proceed, my lords. It's an IA 6920.
At whose instance?
Originally the petitioner home buyers were before the Karnataka High Court, but now they are before the court also. They filed a transfer petition seeking transfer of all the petitions.
Who is the petitioner before Karnataka High Court?
The home buyers only. But now since the CBI here is, my lords, already investigating the same project, my lords, on the basis of the transfer petition itself, my lords, the notices have been issued in the transfer.
Then why you are keeping that matter pending there?
My lords, the transfer has to be allowed by this court then, my lords, so that all the matters are transferred to this court. But we informed the Karnataka High Court that the notice has been issued way back in 29th of April 2025. But the Karnataka High Court is still proceeding, saying that there's no stay, so we will proceed with the arguments. My lords, there can't be 2 parallel proceedings that can go on. My lords, we only request let the Karnataka.
It's only because of your instance.
But now since the amicus is also cognizant of the same project, the home buyers and the CBI is also looking after it, my lord, investigating the whole project, my lord. Let not the Karnataka High Court proceed then, my lord.
I can examine the matter.
You don't know where to examine. First to give a copy, let us see.
That's been supplied, my lord. That's 17.
Your Lordship, if I may, Your Lordship, I filed an application for impleadment, IA number 305205. Your Lordship.
We are not permitted you to, you necessarily start interrupting the input.
I apologize, Your Lordship.
कहाँ से ऑपरेट करते हो ये ऑनलाइन को? किसके पास है यहाँ पे? Mr. Jain, just somebody will seek transfer of the petition.
So,
are these really involving the same point?
I'll do that, sir.
So only then you say in the transfer petitions, let copies of the original writ petitions which are pending before the High Courts, the transfer whereof is sought to this court. Copies and soft copies be supplied to the land vicus to enable him to find out prima facie whether the issue involved in those petitions is similar to the ones pending consideration before this court.
Manoj, there's just one more request, Manoj. With respect to the CIBIL, because CIBIL is also a party before this court. Manoj, the difficulty what the home buyers today are facing is, Manoj, they go to the banks for their medical, Manoj, they need loan for education purposes of their children, Manoj. The bank is refusing the loans, saying that your CIBIL is absolutely negative.
We can't
Manoj, may consider that these petitions,
next slide.
Malaj, the two emails, Malaj, which have been received by the learned amicus, Malaj, by the L&T and PNB, Malaj, they filed by Malaj. The only issue is, Malaj, that the petitioner is not my borrower. I have nothing to do with that matter per se.
There may not be. You people enter into very innovative ideas. You people enter into so many agreements. Correct. We are not going into.
Malaj, there are other matters where
the home buyer is not the director. I have contract. You have contract with someone else who has funded that to the.
Those particulars matter. I have nothing to do. L&T is not even. They are not even the borrowers. Neither PNB Housing Finance and those particular matters. Other matters they are. So we have not moved any deletion in those.
We will not say anything. Let CBI investigate and find out.
Very well.
Consider making this list of 45 cases so that available to the council for the party so that we can better assist. We don't know where our case stands in the CBI list, whether it is being considered, not considered. If
we can't really give you the facilitated individual reports, please.
No.
We are not simply facilitators here. We are only examining question of law.
Lord, may I make
exactly?
May I make a
that we know where we stand.
Just may I make a small request, my lords? I am appearing in item 17.133. Lordship had made interim order absolute, and Lordship had directed that one unit will be reserved. My lords, we have served him. My lords, he is not complying with the orders passed by this honorable court on 22nd of July, my lord.
No, they have not complied with.
Not complied, my lords, at all.
Who is appearing?
My lords, Oasis Builder is the party respondent number 4 in that SLP. My lords, we have served them with all the means by Dasti and everything, my lords. But they are not, my lords, obeying the order.
What is the name of the builder?
Oasis Builder, my lord. Oasis Builder.
What is the name of the person?
Person, my lord. My lords, the name of the person. My lords, I have what the party in the SLP is through its director. We will find out the name, my lords. I'll find out the name, my lord.
Unless you give the name person, what action we can take?
My lords, I'll find out the name of the director.
Right. What was the order we had passed?
Lordships had passed an order on 29th of April that one unit should be reserved. We served them. Then on 22nd of July, Lordship.
In SLP, in petition number so. This court passed an order on
29th of April.
29th April 2025.
Yes, 29th April 2025. Confirmed on 22nd of July 2025.
Confirmed on 22nd July 2025 in terms whereof the builder cum developer is obligated to keep one apartment reserved or what?
One residential unit reserved for me, my lords.
To keep one residential unit reserved for the petitioner. It is pointed out that neither the builder cum developer has filed any reply, nor has entered appearance. Similarly, the above stated orders are awaiting compliance. Who is the managing director, CMD, chief executive officer? They have so many brand names.
Yes, my lord. My lords, I'll give the name of the director, man.
Then let available warrants be issued to secure the presence of so and so person in the sum of rupees 10,000. Which place?
My lord's office is at sector A17, sector 2, Noida.
The Commissioner of Police Noida is directed to secure the presence of the above stated person and produce him before this court. In case of any resistance, the available warrants will be deemed to be non-available warrants.
So, my lords may clarify that in IAs where notice has been issued, the check bouncing proceedings will be stayed.
Madam, we have stayed in your case.
Obliged.
All right, now thank you very much. Give some time for the other matters also. We will see what is to be done. Mr. Jain, let Mr. Jain file the report, then it will follow the direction. And Madam Asurya will the CBI is also directed to file the next status report on or before the date fixed.
My lords, your lordships
Lords-
will hear the
My lords, I
NBCC
seek
the
permission-
Supertech NBCC matters are listed tomorrow, which is what your lordships had tagged on the last occasion. Those will come up tomorrow.
Those are tomorrow.
Those are tomorrow. In fact, my lords, in that
But those were segregated.
those have been segregated. And my lords, in that matter, your lordships have directed me to file a convenience compilation. All of the convenience compilations have been filed. Those can be argued tomorrow.
It will be convenient for us if you give it tomorrow.
Lords, in fact, your lordships had passed that order in May when your lordships were sitting with my Lord Justice Singh. They're all prepared and filed with the registry. But Lord, we can also carry copies if your lordships.
In those matters also, Mr. Jain, you are there to assist us.
No, Lords, he's not there. Lords, in that matter, that is the NCLAT has already appointed a court committee. And Lords, in fact, what had happened, Lords, was this: that pursuant to your lordships,
We'll argue tomorrow. Not
I'll argue that tomorrow.
Exactly. This is that matter where MBB and this
NBCC has now been directed to.
That is against the main Supertech, the holding companies.
My lords,
I'm in.
kindly be there tomorrow. We will see that what is.
I'll come forward.
I'm for one of the interveners, my lords.
But,
In my case, FIR has been registered against the builder, but there's a serious issue of double sale of flats, which has not been considered. All I'm requesting is that the allegations in the IA of double sale of flats, where the single flat has been sold to multiple parties, may also be considered.
Individual cases to be taken up.
Lords, in just one Lords indulgence, Lords, tomorrow, my Lord, the lordships may permit me to appear through virtual conference because I may have some difficulty coming physically.
You can appear online and not.
I'll come up. I'm deeply.
It is only when somebody pounds upon us through online, without realizing that we are dictating order, we are hearing some other arguments. That creates problem.
my lords, the petitioners in item 17.185 and 17.98 seeks permission to withdraw the writ petition and
Very good, very good.
pursuant to settlement agreement. If the lordships may.
How many matters you have withdrawn today?
So just these two.
These third.
No, these two that I am seeking permission before.
Allow me, allow karo.
Thank you, my lords.
Give the number. I'll see what's to withdraw. Kar do.
That's it. My lord, I have filed 3 IAs in Himanshu Singh matter. Notice has been issued. Kindly stay the criminal proceedings.
Criminal proceeding?
Criminal under 138 against the petition applicants here.
138.
Yes.
Who are you? Home buyers or what?
Home buyer, my lord.
Home buyers. Who has filed 138?
Banks have filed, my lord.
Bank has filed. And you have that subvention tripartite agreement.
Yes, my lord. Tripartite.
All right, stay kar do.
I submit. Submit.
Give your IA number, etc.
Yes, all right, my lords.
And please, for God's sake, furnish details of every case to the learned amicus. Otherwise, last time probably we told or we will start dismissing those cases. Wherever now we have granted extended time, all right, 2 weeks kar do usme. 1 week within 2 weeks kar de, and give 4 weeks Mr. Jain. 3 weeks thereafter. 3 weeks after 2 weeks. In case the petitioners fail to furnish the requisite information as per the format prescribed in our order dated 20th January 2026, within the extended period, it is made clear that such cases shall be liable to be dismissed for non-prosecution.
Lordships, in item 18, respondent number 33 to 35 has not filed counter affidavit. And Lordships, a few of respondents has filed counter affidavit, and I seek.
Which item are you arguing, sir?
Lordships. 18 item, Lordship. 18.
18.
Yes, Lordship.
Jitendra Kumar Pandey.
Avanish Kumar.
Now tell us what is the problem.
My lords, the petitioner has misled this honorable court by saying that he did not sign the petition before the High Court. My lords, may kindly have the have page number 21 of my counter affidavit, where he went to the High Court and got his photographic affidavit attested for the purposes of filing the writ petition, in which the impugn order was passed. My lords, may kindly have page 21, my lords.
If there are, look at, we have said our order. Meanwhile, no confidence motion against the elected office bearer shall be kept in abeyance in view of the fact that 12 members who are purported to be signatories to this resolution have submitted affidavit that neither they signed nor supported the no confidence motion.
Yes, my lords.
So let the collector examine this. How can the High Court say that collector can't examine this question?
My lords, as per the scheme of the Act, under section 15(2),
We have already explained that scheme of the Act.
my lords, the section 15(2) of the Act says that collector is not empowered to issue directions to the
Collector is not empowered to ascertain whether they have signed it or not.
Yes, my lords.
In a case where the signatures are there,
Yes, my lord.
then he can't call one by one to verify that these are his signatures.
Yes, my lord.
That is not his prerogative.
This is what is happening.
But if somebody, if I go to the collector, that somebody has produced a no confidence resolution,
Yes, my lords.
which purportedly contain my signatures, and I have not signed it, my signatures have been posed, is he not entitled to verify? He is.
My lords, out of 35 respondents, 29 respondents have already filed an affidavit before this honorable court that they are in the favor of no confidence motion. My lords, I have filed the additional affidavit before this honorable court that they are in favor of no confidence motion against the block pramukh, Kshetra Panchayat of Sultanpur.
That makes the things more dubious and doubtful, both. They are giving affidavit to him also, they are giving affidavit to you also.
My lords, my colleague direct the district magistrate of the Sultanpur to conduct the no confidence motion within
First we will tell him to verify whether they have signed, and if they have signed it, then he will put up before the no confidence.
My lords, may pass directions to because my lords, the term is expiring in this April only. So in any case, if this matter is prolonged, the SLP will get infructuous, my lord.
Let it be done infructuous. Let them continue. They are elected persons. It's not that they are backdoor entrants. Once more continuance motion, once more confidence motion. With the writ petition, then affidavit. जो पैसे दे देता है उसी को एफिडेविट दे देता है.
Yes, that's what is happening.
ये हो रहा है ना?
This is actually what is happening.
What happening?
Yes, yes, my lords.
इनको सबके खिलाफ एफआईआर करा दो इसी एक्ट में.
That's why, my lords, I am praying that a direction may be passed to the district magistrate of the Sultanpur to conduct the flow test.
ये ऑर्डर कर देते हैं कि इसमें कलेक्टर की बजाय we direct the commissioner of police to verify, and wherever it is found that there is some kind of extraneous consideration.
Very well, my lords. Very well. Very well.
They should register FIRs under PC Act and get them arrested and debar them from contesting the next election. That's the only way out. Huh?
Yes, lords. Yes. Very well, my lords. Very
well. They are blackmailing. Right on. Leave granted. The petitioners have laid challenge to a division bench judgment dated 8th December 2025, passed by judgment dated 8th December 2025, passed by division bench of the Allahabad High Court at Lucknow. Whereby the communication dated 21st August 24 of the district magistrate, which place?
Sultanpur.
District Sultanpur, Karaudi Kala block.
District magistrate Sultanpur.
Yes,
yes, my lords.
UP
has been declared to be without jurisdiction, and consequently a direction has been issued to proceed with the inverted commas no confidence motion as per the rules and the statutory provision. Say the election of This was a block pramukh.
Yes, my lords, block pramukh.
The election of block pramukh of
Karaundi Kala,
Karaundi Kala and Sultanpur.
District Sultanpur, Uttar Pradesh.
of so and so was held in the year 2021.
Yes, Lord.
Yes.
Was held in the year 2021. In which whom the petitioner declared elected?
That's Vinod Kumar.
In which petitioner number 3 was declared elected. Next paragraph. A notice was issued on 30th July 2024 a notice dated 30th July 24 was submitted before the district magistrate, purportedly signed by 36 out of 48 elected members, for moving no confidence motion against petition number 3. Subsequently, 12 out of 36 signatories to the notice allegedly submitted their affidavits before the district Panchayati Raj officer, stating that neither they have signed nor supported the no confidence motion. One more elected member was disqualified due to incorrect mentioning of his ward number. The district magistrate, having received 12 affidavits, passed an order dated 21st August 2024, holding that statutory requirement under section 15 in bracket 2 of UP Kshatriya Panchayat and Jila Panchayat Adhiniyam 1961 first
Having received 12 affidavits, caused an order to date 21/8/25. Holding that statutory requirements this to that and zero comparison to 19.
Holding that since the statutory requirement in section 15(2) of so and so, namely that the written notice must be signed by at least half of the total elected strength, was not satisfied, hence the initiation of no confidence proceeding, hence the request for initiation of no confidence motion proceeding was liable to be rejected. Next paragraph. The aforesaid decision of the district Panchayati Raj officer cum district magistrate was challenged before the High Court, and while the impugned judgment the High Court has set aside the same on the ground that a district magistrate has no authority to verify the signatures of members who have signed the no confidence motion as was held by the full bench of that High Court in a previous decision. So the High Court the High Court consequently set aside the order of the district magistrate and directed to proceed with the no confidence motion. Next paragraph. The aggrieved appellants have approached this court. Next paragraph. While examining the scope of powers of the district magistrate under section 15 in bracket 2 of the Act of so-and-so UPF, this court in civil appeal number so-and-so titled Ranjit Kumar Maurya versus Ashutosh Patel and others, has held as judgment dated May 2, 2025 has held as follows. Para 7. Next paragraph. It may be seen that while the collector is not competent to return a finding as to whether the affidavits appended with no confidence motion were bore genuine signatures or were forged. However, if the no confidence motion has been withdrawn by some of the signatories and the remaining and the members and the signatory members are far less than half of the total electoral strength, the collector was very much competent to decline to initiate the no confidence proceeding. Taken by you in this case. Right. The contesting respondents have in their counter affidavit relied upon fresh affidavits given by those very 12 candidates who had earlier given affidavits to the petitioners withdrawing their support from no confidence motion. It is apparent that some of the elected members are switching sides purely for extraneous consideration. This kind of dishonest or extraneous practices can cause irreversible damage to the democratic institutions at the grassroots level. It becomes bounden duty of the authority not only to ascertain the genuineness of the affidavits which are frequently exchanged, but also to hold a deeper probe of the extraneous considerations behind such frequent changing minds. Next paragraph. In the instant case, the term of the elected body is expiring in April 2026. Since the no confidence motion is sought to be supported with such applicants to the with the support of such signatory to the no confidence motion whose own conduct is highly doubtful, we refrain all those 12 members from casting vote in support or against the no confidence motion. That's the only punishment that should be given at least. Resultantly, the collector, the district magistrate, which place it was?
Sultanpur.
Sultanpur.
Karondi Kalan, Sultanpur, Uttar Pradesh.
Will take a fresh call as to whether or not the remainder of the members can move any such no confidence motion, and if so, whether such motion should be allowed to be entertained at this belated stage when the term of the elected body is expiring within a very short span. So ideally, this is not the time for a by-election. Is not the time for a by-election for a very short duration. Let therefore the collector so and so place take an appropriate decision after hearing both sides.
Natural decision is the
Recovery proceedings against the block promote is going on for rupees 5,69,000. He has misused the funds in the Manrega scheme, my lords. So let there be stay on the powers, administrative powers and financial powers of the block promote, my lords. In the meanwhile,
we have forwarded, we have sent you back to the collector. You make a complaint there. Collector will examine.
Very well, my lords.
Obliged. Please. 19 is the contempt
We
proceeding.
were supposed to comply, my lords. I'm for the alleged contempt 1 and 2. Once we have made the application and we are awaiting a response for the bifurcation of that khata, my lords, for the purpose of the cancellation of that agreement to sell. Your lordships have the last order, 10th October 25.
Yes.
Yes, lords. Lords, at
10th October.
I beg your pardon?
10th October.
10th October. Yes. Lords, para 4, it was stated on our behalf that it will take 3 months to get the deed of cancellation registered. And we were to file a further compliance affidavit. Now that compliance affidavit has been filed, in which, my lords, if your lordships will have that compliance affidavit, we had applied, in Bangalore, there's been a small development where the Bangalore, the BBMP has been replaced by the Greater Bangalore Authority. So the bifurcation of the khata which is required for this extent of land on which the agreement had been registered has now got to be cancelled. So we have made that application. The BBMP earlier in December told us that they did not have a provision, after which we have reapplied on 10th January 2026. And at para 11 of our additional affidavit, we have received the undated draft khata and that has to be finalized. So we are asking only for a further 3 weeks to complete this compliance, my lords. We believe that in this 3 weeks, the authorities will be able to comply and that we'll have that reversed. We believe, my lords, there isn't really a contempt, but we are going to fully comply, cancel everything. We'll come back and then make a clean breast of what our position is. Because that survey number covers different pieces of land. So what was the subject matter of your lordship's order is not that land on which the execution was done, but in any event, we're cancelling that.
Agreement was entered into, my lord, in respect of survey number 108/1, which is a suit property.
Correct. That's correct. That's correct. 108/1 is a large piece of land with different extents within it. But in any event, we're cancelling that, my lord. So your lordship can take it from me. We're cancelling that fully.
So the cancellation deed has not been.
It will take a few more weeks to process. It's not in our hands, my lord. So I've asked for 3 weeks.
So let us see.
Hoping that it will be done by then.
I beg to appear, my lord, for respondents 3 and 4. I believe it must be through an error I've been brought in. The reason being that your lordships had passed a status quo with regard to the suit schedule property. My lord, although my property was part of the original plaint, subsequently, my lords, there was an amendment application filed by which it was dropped, and that was allowed as early as 2015. And it's not part of the suit at all. And in fact, even in the SLP, I've taken out an IA to be dropped as a party because I am not in whatever is the suit schedule property, I have no interest at all in. And so far as the property I am interested in, that, my lords, even the amended plaint is on record, which will show that my property has been dropped from the schedule. And
that is an issue, Mr. Sundar. The point is that today we are only on the question of violation of an interim stay.
Absolutely. But I've been made R3 and R4 in the contempt. That's why, my lords.
That we will, once the Mr. Gopal Shankaran says that.
Part of respond number 3 and 4 also.
Gopal Shankaran and senior counsel representing respond number
1 and 2. Let's continue this 1 and 2.
1 and 2 state that it will take another 2-3 weeks in getting the
deed of cancellation registered.
Deed of cancellation registered.
But so far as respond number 3 and 4 is concerned, they are relying upon the amendment, my lord. Amendment has taken place with the consent of both the parties, to which I am not party, my lord. And therefore, my lord, so far as the amendment is concerned, my lord, it will not wipe off the schedule of the original suit, my lord.
We will see what is, let us see the proper cancellation, what survive. Post the matter after 3 weeks also.
I have undertaken to file a compliance affidavit the minute I get it.
On doing the needful, a compliance affidavit on behalf of respond number 1.
After 2 weeks, huh?
3 weeks.
Lordships.
3 weeks.
Your lordships will be giving some specific date, my lord, of 3 weeks. Grateful.
Item 20 minutes.
Dear Rona.
Please, my lords.
34.
There's only 5 dates are important in this matter.
Minutes before the petitioners begin, may I submit minutes? They have come to this honorable court on singular ground, saying that one identical issue has been pending with your lordships. So
That's a different issue.
Honorable High Court should not decide the issue. Their own pleadings is that's the only issue they have raised. And that was decided last week, saying that one UGC regulations prevail over the state legislature or the university statutes. And that's the issue they wanted to raise here, agitate here. Their pleadings, I'll take your lordships, subject to your lordship's pleasure with regard to whatever the hearing.
Lord, that is not
It is the issue they have raised that has become now concluded.
That is not the issue.
May I just pass on the judgment?
Petition my learned friend is arguing. I'm arguing the different petition. Let me place. Well, it's on 5 dates, sorry, just note for us. This is a case without allowing me counter, directing a full stay, allowing the writ petition by holding that the state's enactments are nullified and regulation 7.3 of the UGC applies. In the order of the High Court does this. Now note this, fellows. On 12/5/25, during court vacations, suddenly, fellows, a supposed PIL is filed. I'll just give 5 dates, fellows. 12 May 25, a PIL is filed in Madras High Court, challenging the validity of amendments pertaining to the appointment of vice chancellors. Amendments have been made
in the exercise of power by the state government, quasi-state enactments under the list 3 entry concurrent list. This is filed suddenly in vacation on 12/5. Whereas notice is issued on 14th of May, including a notice on stay. No urgency is shown. Matter is listed for 21st.
Stay seeking appointment of the vice chancellor.
Stay of the entire regulations and rules and statutes by which the state appoints.
Seeking stay of the amended provision.
Yes, amended provision. Correct. Notice is issued for 21st on 14th May. A transfer petition is filed in the Supreme Court saying similar identical matters of some kind are pending here. Forget that, Malas. The state's transfer is mentioned on 19th May. In the High Court, Malas, on 21st May, 5 days later, having issued notice, the impugned order is passed without allowing me time to file counter. And the entire writ is allowed. Now turn to my written submission. I'll just highlight 3 or 4 things for us. Give the written submission note. Give it quickly. Just come to us 2 or 3 things. Give it quickly. Don't play with it. So my first point is my para 2.1. I'll be only selective.
First point, Mr. Naidu, yes. Tell us on factually, is it correct that after 5 days the matter is, petition is allowed without any notice to them?
May I submit, Millets?
Without a counter.
It is yes or no?
Millets, it is I who argued before the Honorable Madras High Court. I have got personal knowledge. My lords may kindly see page number. It's been recorded by the Honorable Bench there saying that one, look, we put you on notice, we gave you time to file a reply. You have not come up with any reply. Today you are again asking for more time. All right, put things on hold.
Detailed reasoned order.
Yeah, my lords may kindly see, Millets. Put things on hold so that we'll consider your plea. May I just read that one, Millets?
No, can I just first place my...
Where are the ROPs before this, before the final order 21st May?
I beg your pardon?
Do we have the ROPs before 21st May?
Yes.
The orders passed by the High Court.
Volume 2 it is.
Volume 2.
Orders passed.
At 652.
652.
This is I'm grateful. I didn't
First
understand.
hearing was 14.
652 minutes.
Yeah, this is the first
It's
hearing.
a very important question which is followed. Just kindly see this. This is not the way to first grant a stay, let me suffer and then say now we'll decide it later. Come to 652, admit, issue rule NISI, call for records in 8 weeks. Does my lord have it? Does my lord have it?
My lords, it's only an interim order. The matter is still pending. It is not a final disposal.
What is being argued is in the interim stage, a statutory rule has been suspended.
Yes.
Whether that sort of a compelling prima facie case A was made out, 2, opportunity was given to the respondents to rebut the case that you seek to make in the writ petition.
Yes, Millets.
Well, the balance of convenience is not first stay and then argue. It is first argue and then stay. That is the balance of convenience.
Major your concern, Dr. Singhvi, that these are statutory rules having a presumption of constitutionality.
Now turn to the query by law asked.
Honorable High Court has said twice over the Honorable Supreme Court has decided the issue and it's been squarely covered. Anyway, you wanted to fight. My lords may kindly see it's been said.
We are not on that point. The order may be legally correct.
We will be able to satisfy our
Yes.
justice, my lord.
No, what they have said. Yes.
Next, this one. This is order 15.5. This is.
No, we are not going to examine this issue, Mr. Mehta. The High Court should examine.
That's why, Millets, the time has been given.
The case was moved in a vacation.
The learned Advocate General was requested, please give us an undertaking. You will put things on hold.
My learned friend is.
Whatever the time you want to take, you take.
Lord, my learned
They
friend is
said
not
no.
correct. I was
Cannot
there in
give
the
you
court.
that assurance.
Lord, matter was moved in the vacation court. The portfolio doesn't say that, my lord, these matters, my lord, will be placed before the vacation judge. Portfolio clearly says any emergent matter that can be moved before the vacation bench. Therefore, my lord, the portfolio doesn't permit, my lord, this matter to be placed before the vacation bench. But, my lord, the person comes from Tirunelveli, my lord, he waits, my lord, after this notification was issued 1 month, my lord, before it was issued.
2 months old. He
Yes, he comes in the vacation court, bypasses Madurai High Court. He files, my lord, this writ petitions here and moves, my lord, urgency slip, my lord. Matter was taken on 14/5. Learned judge, we requested, saying that we had filed a transfer petition before the Supreme Court. Learned judge posted the next week, my lord. And despite our arguments, my lord, repeatedly saying that we have not filed a counter affidavit, please hear us. My lord, the learned judge, my lord, switched off the mic and passed an interim order and made certain remarks against me also. But something unheard of, my lord, the way it was conducted.
My lord, this is completely unfair and unethical.
Can I say something else? Your lordship has operating rules.
Attributing motives to the court if they don't have a point.
Very unfair, my lord.
Which acts?
Your Lordships may,
The amendment acts are quite old.
please, your Lordships may examine your Lordship.
Lord, he has no role at all.
We are not examining on merit, we are examining the manner in which the order is.
Yes, exactly, my lord.
But disturbing us.
That's why.
Lord, Mr. Mehta has no role at all. It's a state legislation being challenged. Lord, he is appearing for UGC. Why is he, my lord, supporting it?
My lords, kindly come to page 5, para 4. Kindly have a look at para 4. What's been said about the whole process? Para 4, my lord. Para 4 of the impugned judgment, page 5.
Allow me to place my case for the petitioner.
The writ petition. When it comes to the procedure, it has to be set right only to the extent merits they can as well argue.
Let me place my
The writ
case.
petition was listed for hearing on 14/5/25 and was admitted. Even when the matter was taken up for admission.
Why in a vacation bench?
Yes, Mr.
This was not filed during vacation. This was already a pending matter.
Millets, I have complained that they are going to complete the whole process.
You have vast experience. Please tell us.
Yes, ma'am.
Vacation court setting, question of constitutionality of some university statute. What is the daring hurry?
May I give the answer for that? Kindly come to page 7 minutes. Kindly come to page 7. Just have a look at page 7. Just have a look at it. Page 7, para 7.
Yes.
My lords, may kindly see para 7. The learned Advocate General does not dispute the factual position that government orders have been issued constituting such committees and that the such committees have issued notifications inviting application. Last 3 lines, my lords. We wanted to know whether the process could be put on hold till the stay petition is disposed of. The learned Advocate General was unwilling to give any such undertaking.
Assuming some illegal appointments are made, it does not prevent the High Court to set aside them. If the High Court finds that yes, there is something the state has in tearing hurry, made some illegal appointments, the High Court can always set aside.
For that purpose, they have said, please give us an undertaking so that we can consider. My lords, it's not that day on the same day it has been disposed of. Earlier it came. The learned Advocate General entered his appearance and court told him that by next time we will consider this one. Meanwhile, you come back with your defense. The next time they came and they said we wanted more time. The court said that one, all right, we'll give you more time so that it could be considered. Meanwhile, put things on hold. They refused.
These laws came on 11th of April. In May, suddenly in vacation, without any urgency, it is moved. A date is given 5 days later, no counter is filed. The procedure followed is first stay, then arguments. The actual procedure should be first arguments, then stay. Exactly that has happened in 5 days, 14th to 21st.
At length it had been argued. At length it had been argued. More than the whole half a day was taken for all parties concerned. And my lords could see, para 4, what's been said. We put them on notice and informed them that the petition for interim relief would be taken up on 21/5/2025. Well in advance informed. And they came the next time on this day.
All right, Mr. Nadu.
I wanted more time. Now, my lords, even otherwise, the whole thing has become infructuous.
You argue all these issues before the High Court. We are sending it back. We will set aside this order. Right on leave granted. Third learned senior counsel, Sir Dr. Abhishek Manu and Wilson learned senior counsel on behalf of the state of Tamil Nadu and their authority. Sri Naidu learned senior counsel on behalf of the.
Yes, minutes.
On behalf of Supreme Court.
State of Tamil Nadu. He's a writ petition. He's a writ petition.
No,
yeah, writ petition. Who actually turns out to be an office bearer.
On behalf of Supreme Court.
skips Madurai Court.
We heard Sri Tushar Mehta, Learned Solicitor of India on behalf of University Grant Commission, and Sri Naidu, Young Senior Counsel on behalf of Responding Report. That's it. Having regard to all the attending circumstances, say the instant appeal is directed against an judgment dated 21st May 2025, passed by a division bench of the Madras High Court, whereby the court stayed the operation of the 10 bills to the extent that they take away the power of appointment of vice chancellors of the universities from the chancellor and vest the same in the state government. That's paragraph. Since the main case is pending before the High Court and the impugned judgment it is purportedly an interlocutory order, but for all intents and purposes has the effect and impact of a final judgment, comma, it is not necessary for us to express any opinion on merits of the case. All that we wish to observe is that the appellant state and the authorities ought to have been given a reasonable time before passing the impugned order cum judgment. First of, on this ground alone, comma, the instant appeal is allowed, the impugned judgment and order cum order dated 21st May 25 is set aside, and the matter is remitted to the High Court at Madras. We request the Honorable Chief Justice to list WMP number 20576 stroke 2020 to list WP number 18374 stroke 2025 and WMP number 20576 of 2025 before the bench presided over by him, semicolon, grant reasonable time to the state and its authorities to file their counter affidavit, and thereafter hear the parties on interim relief from if so required, or preferably the main writ petition itself may be decided. But what you will gain in the main writ petition, Mr. Wilson, after the 5 judges opinion of this court,
So far as this issue, Lord, is not
that
considered.
leave it to the High Court.
This is a different issue.
May I add only two things?
Entirely different.
May I add two things, Millers? There was a stay, or still up to now, but they completely disregarded. Even on 24/1/2026, 27/1/2026, they went ahead by conducting interviews.
Lord, impugned
They have
order
never
itself
adhered to. They have never adhered to.
Lord,
any
impugned
of the
order
stay.
itself permits
First
it.
thing,
Impugned order allows.
let them not. Let them not.
No, Lord.
Yes.
3 years.
After
After 3
kindly
years, we are not able to fill
we
up.
were
Lord, 20,
contemplating a
16 universities, they are chasing us. Filing litigations one after
the
another.
contempt case.
Lord, I can't keep my university headless.
See, Millers, when stay has been there,
Lord, that cannot be done.
Please listen us.
It's an illegal
and
order.
they ignore Millers saying that cannot be done.
Please allow to have
Shame, my Lord, to keep my universities vacant, my Lord. They are filing litigations one after another. They have been set up by persons.
Please remind yourself, it is not assembly, it is court number 1, Supreme Court.
And for him that applies, not for you.
Your Lordship, since it's an illegal order, then it is heard again. It is no further stay to be given as he is asking. Yes.
This order was passed in May 25.
Yes.
Almost 1 year it has been operating. We are only pointing out that we need not to mention, but don't, that we are reminding the case on your argument. Don't make an appointment till then.
Now and then, no. Between now and
Millers, just your Lordships have heard.
May I say this, my Lord?
We cannot keep.
May I say this? Any appointment, my Lord, will be subject to the
we have
result of
gone
it.
ahead. They admit that we have gone ahead.
Can I say something?
Just a minute, please.
A legal answer.
Lord,
Just
Notwithstanding
30
the
seconds.
stay,
Mr. Court,
1 month is not going, you see, look,
Page 27,
Dr. Singhvi,
order says,
Dr. Singhvi,
with the search committee.
Dr. Singhvi,
Order says.
Dr. Singhvi, please now consider, we are not going into that.
it will be
merit of
another
it.
form of stay, my lord.
These are only bill. These are only bill.
No, my lord, Act has come into force.
No, act.
Act has come into force, my lord. It was
they
notified.
themselves have
It was
pleaded
notified.
identical
Otherwise,
questions.
he cannot challenge.
Yes, my lord's query is taken care of by the impugned order against me. It says
Millards,
there are 30
in all fairness,
we
since my lords have said,
to staying that part of the legislature which takes the power of the governor to make the appointment. In fact, we do not even propose to stay the Constitutional Search Committee. If interim stay is granted, that position will, it says so itself.
but that doesn't say that. Read the complete one.
Para 30 says so. Between just,
May I
they
just-
should not do it. They're not doing anything between now and the hearing. Say that. Shall I say it? Shall I say it? Between now and the
But
hearing.
still,
Between the now and the hearing, we don't intend to appoint Willis. Willis, may I take care of the? Willis, may I take care of the Honorable Chief Justice's concern? Between now and the hearing of this case, which is proximate, there is no intention to appoint anybody.
Kindly record it.
It will be
We'll-
recorded.
No, man, I am saying so. Why should
That's all we wanted.
Then we don't want to embarrass you by quoting and
we
everything.
don't mind being embarrassed.
His colleague says we'll go ahead.
No, we have an objection in embarrassing you.
I have no problem being embarrassed.
And Dr. Singhvi and Mr. P. Wilson, General Senior Counsel state that from today till the matter is decided, till the interim stay issue or the final or the main case is decided by
Further.
the division bench headed by Honorable Chief Justice of the High Court, no appointment shall be made.
May
No appointment shall be
He is a
made.
resident person to give instructions, Willis.
Why we are saying no appointment shall be made?
my lord, will religiously follow your lordship.
Next paragraph. In light of the fair stand taken on behalf of the appellants,
My lord, till the application is decided, my lord, not the main case, my lord. Because that
well,
WMP
till the
application.
saying something better, we were saying something better.
Yes, my lord.
In light of the fair stand taken on behalf of the appellants, we request the Honorable Chief Justice of the High Court to take up the main case and make an endeavor to decide the same on merits as early as possible and preferably within 6 weeks.
I just add one last thing, Millards, for my lord's kind consideration? May I just have one thing, Millards?
When this
Very fair order.
Justice Srivasta's retirement is there on 8th March.
That's what I was about to tell.
I said it will be
My only
posted before
prayer
the
is this,
appropriate
Millards.
bench.
Let him,
Post before the
Any
appropriate
jurisdictional bench, Millards, any jurisdictional
Post
bench
it
that
before the
presently
appropriate
there.
bench for the Lord Chief Justice's Willis roster.
Any jurisdictional bench, Millards. Any jurisdictional
That's a
bench.
fair point.
Otherwise, it casts
He can't
aspersions
do
on
it,
the
he can't
previous
do it
bench
on
for
8
no
March.
reason.
There's no way he can do it. You have lots of other.
Reputation is the only asset of a judge.
the matter may be taken up either by Honorable Chief Justice or he may, if so deemed appropriate, may entrust it to some other appropriate bench. Then say, we request the High Court, don't say Chief, then we request the High Court that in keeping in view the fair stand taken on behalf of the appellants, we request the High Court to make an endeavor to decide the main case within 6 weeks.
I'm deeply
Grateful,
very
Millards.
deeply-
Deep applause.
All the remarks, my lord.
Millards, as
against the
parting one,
counsel were
Millards.
eschewed. All the remarks.
Against the council, but
It
that
is clarified that we have not expressed any opinion on merits.
Millards.
For appeal is allowed, the impugned judgment is set aside.
remarks are expunged.
In view of the fact that the impugned order has been set aside, any observations, remarks, or directions contained therein are deemed to have been annulled.
Deeply.
Are deemed to have been annulled.
Millards. While parting, Millards, we have also been fair, Millards on our stand. My lords have said the appellants have been fair. We are also fair, Millards.
Don't ask for.
We have only said this is the
fairness,
position.
Don't ask for.
It's always been fair.
I'm the appellant.
Lord, only one request, not on the merits. If your lordships can consider adding one line, this would not reflect anything on the bench which passed the order.
Exactly.
Because your lordships have said to be,
They've done their job, Millards.
Since we
they have, Lord, heard it at length.
Since we have set aside the impugned order primarily on account of a technical reason, on account of a technical ground, comma, our order shall have no bearing on the merits of the main case.
Obliged.
On the adjudication of the bench, previous bench. On the adjudication of the previous bench.
It will have no reflection on the previous bench.
In fact,
That's all.
he's bringing the bench into it unnecessarily.
No,
That
Mr.
you have brought it.
Mr. Wilson made almost allegations. That was
Better we don't say nothing more.
Yeah, better not.
Please, sir.
Great.
Lord, item 25.
Millard,
If
The transfer petition has become infructuous.
yes,
But simply there was provision petition.
We withdraw that.
Or we say, in view of the order passed in the main case, the transfer petition has become infructuous.
Great.
Whatever way you want.
Yes, we withdraw it.
well, since your lordships are rising, item 25 is the DDA matter where we want to construct a road to approach the hospital, my lords. The state has filed an affidavit, my lord. Can it be on Friday or Monday, my lord, your lordships?
Monday.
Monday.
Millard, item 28, Millard.
Tamil Nadu DGP
Item 33,
matter, your
Malad.
lordships, the Tamil Nadu DGP matter, your lordships, because the interim DGP.
Today we are occupied with Tamil Nadu or West Bengal.
The lordships have been occupied by the whole map of the country, your lordships. I'm just seeking next.
Tamil Nadu matter.
The Prakashing matter.
Yes.
Prakashing matter.
The very next matter, and this is, we want to take up this matter
Yes, your lordships.
next Tuesday.
Next.
Millard, item 28, Millard.
No, sorry, next Wednesday.
Very well. That
Next Wednesday.
Item 28.
Just a minute, just a minute, just a minute. One incentive giving to all of you, that all left out matter will be taken on next Wednesday.
Can it be on item 33 on Thursday, Malad? Only item 33 on Thursday.
Parties, both sides want a longer day.
No, but except on when?
Mr. Raju, sorry that we couldn't take up this Prakashing matter. We have gone through your note, and thank you very much for very outstanding assistance you have provided so far. On the next Wednesday, is it all right?
I appear for Tamil Nadu.
Remind all that day as a Micus, you please remind to take up that matter. We will take out of turn. Provided you, just you mentioned.
I appear on the other side.
That's it. So both of you can remind. We will take up on.
Yes.
Only item 33 instead of Wednesday can be on Thursday. Nothing to connect it with the item.
33, what do you want?
Instead of Wednesday, we can be in Thursday, next Thursday. Or a day
I
after.
don't want on Wednesday.
Wednesday, Malad, I have some personal
All
difficulties.
right, next Wednesday.
Very well, Malad. Next Wednesday.
My lords, item 26, my lords, if it could be on Monday or Friday, my lords, item 26. It's an LOC quashing matter, my lords. Item 26, my lords, could it be on Monday or next Friday, my lords?
Why next Monday or Friday? You want?
My lords, I'm in some personal difficulty, my lords.
Is it already shown as NMD?
My lords, no, my lords. It just happened to come up on a Tuesday, my lords, on the first date.
Samni, those matters which are NMD, which are not NMD. Take out those matters and list them on some Monday, Friday.
So grateful.
My lords, in item 20,
Circulation on Monday and Friday.
your lordship in
Item 28 is a writ petition, Millard. The Andhra Pradesh writ petition.
that is the
Millard, even though it is appearing to be a miscellaneous item, it's a
final
writ
hearing.
All right, then instead of coming Monday, we will list next Monday. No, it wants a final hearing. Final hearing.
keep it on a Tuesday or
Should be on Wednesday.
Wednesday.
Yes, Wednesday.
Then maybe then next Wednesday.
Yes.
But my lords, in item 23, matter.
Millard, in item 23,
Next Wednesday. Today there were some slightly some lengthy matters. So maybe next Wednesday turn will come.
Millard, in item 23.
In item 23, my lords, there was one application for appointing high power election committee, which has been appointed in respect of
Yes,
state
my
of
lords.
Rajasthan. My lords, the only request is, my lords, the summer courts will start from 13th of April. So all I am requesting.
Sorry, you are arguing, but my mind is somewhere else. Mr. Naidu, in that order, we can mention that Mr. Naidu, write down एक line. Bargain करते हैं ना एक line लिखो. Mr. Naidu, Alliance Senior Counsel, fairly states that so long as the impugned order is set aside on technical ground, he has no objection if the matter is remanded to the High Court for fresh consideration.
He has a point.
He wanted to bring the word for you, you also.
Grateful.
At 4 o'clock, my lord, at 4 o'clock, all three of your lordship's face has smile on the, that's a rare thing, my lord. We are really grateful, my lord.
We can work till, I mean, I don't have.
That's amazing. That's amazing.
8 o'clock. We can very comfortably work.
Milord, item number 23, Milord, the Bar Council of West Bengal has filed an application
Bar
for
council, कितने bar council हो गए इस country में?
Lordship may have it, Milord, on any.
Bar council matters, we have decided what you left there.
Milord, we are only seeking some modification so far as the counting of vote is concerned, Milord, because the state assembly elections are clashing, Milord.
Counting of votes. No, counting of votes issue we are not touching deliberately as of now. There is a request. There are 2-3 other requests by some councils for regarding the mode and manner of counting of votes. We are consciously not touching that issue so far. Let the elections be held. Once the election will be near to over, then you file the application.
Your lordship.
Then we lay down.
Your lordship. That
You will have to give direction because of the.
Milords, in connected item.
This fact that some directions are required to be issued, how, like for example, how to ensure this 30% representation to the women candidate.
Correct.
Suppose how
Proportional representation. Yes.
proportionate.
The statute provides for proportional representation.
Facing Milord is that because
How first
Mr.
preference
Kumar
against
will enlighten us that how it is to be done.
No, in fact, we are working out the modalities, my lord. We'll place
So
before
you
my lord.
prepare a note and you can also, all of you can also prepare on this side.
Yes.
Give us a note. You will tell your note must ensure that the women candidates get not less than 30%.
I understand.
Your benchmark will be not less than 30%.
I understood.
My lord, in item 23 itself, my lord, in relation to Madhya Pradesh Bar Council, was some erroneous fact came in the order because of which the Bar Council of Madhya Pradesh has delegated